My lord, this petitioner, my lord, successful in my lord, Central Armed Police Force, my lord. Central Armed Police Force. He's successful in computer. Friday, my lord, it was for my lord, physical standard test. My lord, he filed a petition, my lord.
Read petition.
Yes, read petition.
Wednesday?
For that reason, my lord, he was not allowed to participate in physical.
Huh?
For that reason, my lord, he was not allowed to participate in physical.
Wednesday?
Yes.
Mayor, your lordship. Also, I pray for listing on urgent writ petition, lordship, listed matter, lordship. The facts of the case, I was transferred, lordship, despite there is restriction imposed by the Assam State Election Commission. And in violation of the election code, lordship, I have been transferred, lordship. At 2 p.m., lordship.
Tomorrow?
Tomorrow, lordship, already, lordship, notice of election is.
Tomorrow.
My pleasure, lordship. So one matter pertaining to dismissal from service, lordship, it's a matter of 2023, maybe come up on Thursday, lordship, subject to.
Not Thursday, next week,
Next Tuesday, lordship.
Next. Why
Please, Lordship.
Tuesday, Wednesday?
May it please your lordship, I beg to mention item 7, lordship. Bans to matter, lordship. Wrongly boosted.
Bench to matter?
Yes.
So? Wait, you wait.
Wait, my lord. No, it's a pension matter, my lord. So these were
Okay, give it to the court master.
May I please your lordship? May I please your lordship? Lordship, may I make a prayer for the listing of a matter? There is an urgency because this is a matter pertaining to dismissal from service. And even after repeated orders, the respondents have failed to file their affidavit.
Give it to the court master.
Deeply obliged, my lord.
With the consent of the other parties, I beg to mention item number 40 and 49. Lordship in
40,
48 and 49.
48 and 49.
Lordship in writ petition, and I has been filed for impeachment. So I need 2 weeks time to file our objection, Lordship.
48 and 49.
49.
You want to file an objection to?
Impeachment petition.
Okay. Miss R.R. Kakoti, Learned Counsel, for a petitioner has submitted that an objection to the interlocutory application filed for implement, seeking implement is going to be filed within how much time?
Weeks.
2 weeks time, and has thus paid for listing of the cases after 2 weeks. The prayer is made with the consent of the learned counsel for the applicant, Miss K. Porali, who is in attendance. The prayer is allowed, list the cases after 2 weeks, only date 2 weeks by now.
In writ petition, there is an interim order.
The interim order, if any, passed earlier shall continue till the next date of listing.
I pray for listing of a writ petition, my lord, next week, any date, madam.
Lordship, item number 14 and 15, Lordship.
14 and 15.
Lordship, we want to withdraw this petition, Lordship.
Okay, Mr.
D. Colita, Lordship.
D. Colita, learned counsel for the petitioner, has submitted that the petitioner wants to withdraw the writ petition. Okay, who are the other sides? Okay,
Guwahati Municipal Corporation.
in view of the above submission made by Mr. Colita, learned counsel for the petitioner. You want liberty or?
Lordship.
They will liberty go to. You have a submission made by Mr. Colita, learned counsel for the petitioner. The writ petition is dismissed and withdrawn, which liberty has paid for. Same 15.
Yeah, please, Lordship. Lordship, our listing request 6 weeks notice for interim relief was issued, Lordship. 10 weeks have gone. 6
Okay,
weeks.
give it to the court master.
There is another matter, Lordship, pleadings complete suspension matter.
Give it to the court master.
Okay.
About the date.
Lordship, I beg to mention 2 items. One is which was ordered to be listed after 2 weeks, and one is which was ordered to be listed after 4 weeks. Writ petition, your lordship.
Okay, give it to the court.
Much obliged.
May I pray for listing for writ petition, my lord, promotion matter. The petition-
Motion matter?
Yes, my lord, the petitioner will be retired from service on 1st November, my lord.
Motion, okay, this week, Friday.
My lord, much obliged.
These were supposed to be listed after 2 weeks in the month of June, my lord, it was not listed.
May I please your lordship? I'm praying for listing of the matter. WBC.
Admission or motions? Okay, give it to the court.
Please, your lordship.
I am praying for listing for order, my lord. After motion not been listed, reasonably to file. Next week, my lord, anything.
May I please, your lordship, beg to mention for listing WPC 3470 for admission. This.
Okay, give it to the court.
Obliged, lordship.
Like to mention 2 items for listing. One is the writ petition and other one is IA civil.
I,
Civil.
okay, give it to the court master. No, mention memo.
May I please, your lordship? May, lordship, I'm praying for listing of a matter. It's a part hard matter, my lord. It was last listed on 5/6/25, my lord.
Before this court.
It was in the court of Mr. Honorable Justice Kartik Ite, my lord.
Make a mention before that court.
Obliged.
Lordship, may I please to mention for listing of a case which was last listed on January 2025.
May it please your lordship. Would you pray for listing of a fresh matter for motion on Friday, your lordship?
Pray for listing of an IA, my lord, for compliance of this honorable court order, my lord.
Compliance of this court.
Compliance of this honorable court order, my lord, in WPC number.
Okay, next week.
Next, obliged.
I beg to motion for listing on IA, lordship. Next.
May I please, your lordship? Your lordship, I beg to mention one writ petition for listing in orders column, lordship. Can it be on Wednesday, lordship?
Daily list for motion, items 1 and 2.
Yes.
My lord, the contempt, my lord. The order is at page 13. The operative portion starts at the last paragraph of page number 16, my lord. In fact, the background of the matter, my lord, that there was an advertisement dated 29/5/2025. That is what has been assailed, my lord. That advertisement is subject matter in item number 2, where my friend appears, my lord. Now, the last date for submission of documents was 31st of July 2025. The petitioner, my lord, he wanted to apply for the post of director, albeit on a deputation basis in the respondent institute. To apply, he has to have a clearance certificate, a vigilance clearance certificate, a no objection certificate, along with the APAR and the ACRs of the relevant years, pursuant to which he applied before the respondent number 4 and 5. That was denied to him repeatedly, my lord. In fact, item number 2 happens to be the 5th litigation in the series of litigation in the matter. Now, pursuant to that, my lord, the petitioner moved this honorable court on 23/7/2025. 23/7/2025, my lord. That was just before the advertisement, the last date ends. Now, your lordship will kindly come to page 16. Page 16, my lord. Page 16, the second last paragraph.
Yes.
Mr. So-and-so, learned counsel for the respondents, submits that since there is a departmental proceeding pending, authorities are not in a position to issue the relevant documents. He, however, has not been able to place any office memorandum or notification or any rule which suggests there is an impact on the authorities with those documents sought for during the pendency of the departmental proceeding. More particularly, when the petitioner has not yet been granted an opportunity to submit his reply after perusal of the necessary documents and prayed for. Considering her submissions made, this court is of the prima facie view that the documents sought for by the petitioner cannot be withheld merely because of the departmental proceedings initiated. Accordingly, the authority officiating as a director of the LGBRIMH, the respondent authority, my lord, and other officials of the institute will ensure that all the relevant papers sought for by the writ petitioner be furnished, enabling him to file for the post in question under advertisement dated 29/5/2025. In the event the departmental proceeding continues during the selection process, then the respondent authority will adopt seal cover procedure in respect of the writ petitioner, that those documents be furnished positively within 3 working days. Thereafter, my lord, there was a communication intimation of the order to the authorities and respond number 4 and 5 in the writ petition, my lord. Thereafter, at page 18 and page 20 are the relevant documents, my lord, where we have alleged simple deliberate non-compliance with the order, where the NOC which was asked for by the petitioner was rejected. The reasons have been given, my lord, at 1, 2, and 3 at page 18. That as per the advertisement dated May 29, 2025, the NOC is to be issued by the competent authority from the lending department. However, in this case, the institute is the borrowing department.
and the advertisement does not have any provision in this regard. Consideration of the applicant's request for transfer on deputation in this case is not outside the normal field of deployment, and hence it does not come under the scope of deputation as per existing Government of India DOPT instructions. The applicant joined this institute on April 1st, 1998, during the time of the Board of Administrators under the Government of Assam, and was an ex-cadre deputation, retaining his lien under the Government of Assam till April 7, 2004, on which date he was accommodated against the created post by the Government of India and notified by the institute by memo number so and so dated April 7, 2004. Therefore, he was already an ex-cadre deputation for 6 years in his entire service, and hence he is not eligible for consideration for ex-cadre deputation for another 5 years in view of instructions issued by the DOPT. Number 4, my lord, number 4, which has already been clarified by this honorable court in the order, the disciplinary proceeding is pending against him, and hence it cannot be, it was a ground for denying him the issuance of an NOC. Number 5, my lord, the advertisement dated May 29, 2025 also mandates a comment upon the integrity of the concerned officer. As per record dated so and so, the reporting authority marked the administrative integrity of the applicant as doubtful, and he was subsequently relieved from the additional charge of medical superintendent by the order dated so and so. Number 6, the Department of Psychiatry currently has a scarcity in terms of faculty, and consideration for sparing the applicant on ex-cadre deputation will hamper the academic functioning of the department and hence will not serve any public interest. Citing these grounds, my lord, the advertisement date has lapsed. I have missed the bus, and I have not been able to, with all the proper documentation, my lord, prefer my application for the post of director, even having served.
What is the advertisement?
The advertisement, my lord, is at page, is at an item number 2, my lord, where my friend argues for the petitioner. The advertisement, my lord, it starts at page 85 of item number 2. Page 85, my lord.
Mr. Dutta, you appear.
Yes, my lord, I am, to my information, the contempt petition has not been received by the,
Notice is not issued. Notice is not issued.
not received, my lord.
The notices.
And,
No, what had happened was that the matter had initially come up on the 18th. Thereafter, my lord, there was a judicial order where this contempt petition was directed to be listed with the writ petition on 22nd. Thereafter, the matter was not listed, my lord. I made a mention before this honorable court. The matter had come up today.
Okay, but these are individuals.
These are individuals, my lord. In fact, the individuals have been made a party in the writ petition also as party number 6 and 7. Dr. Jyoti Hazarika is the administrative officer, my lord. He is respondent number 6, arrayed individually, my lord.
So, Mr. Doctor, you represent this respondents also?
My lord, I have not received, in first case, contempt case, I have
No,
not received
Only,
any. I can, my lord. But
226.
without,
226, who is respondent number 7 there?
My lord, Hemanta Dutta, who qualifies as the officer on special duty, my lord.
In the previous order passed in the repetition,
Yes, my lord.
issuing notice,
Yes.
Mr. Doctor, it is mentioned that Mr. Doctor represents 226.
yes, my lord.
Whether it is correct or not, I don't know, because steps upon respondent number 6 and 7 were registered post.
Yes.
What has
2 to 5,
transpired?
my lord.
Steps taken, whether served.
How it is discernible that they are aware of the directions of this honorable court is immediately when it is communicated, taking the same pleas, they have rejected. Yes.
Right.
From their conduct, it is discernible that they are aware.
They were aware, but
Aware.
notice is not received.
Notice in the contempt has not been issued.
And it transpires that this order, some typographical mistake has appeared in the notice issuing motion.
And there is another aspect.
He represents 2 to 5 perhaps.
2 to 5 million.
In a
2 to
repetition.
5 million.
Because at one place, AK Doctor
2 to 5
appears
million.
for 2 to 6. Then another part steps upon respond number 6 to
Yes.
6 and 7 by
2 to 5
to
million.
AD.
Then Lordship may perhaps issue notice in the contempt
both-
petition and let them.
Both are returnable on both same date.
I'm
It is already notice has been issued.
Yes, here notice has been. IA has been filed for vacating the. There I have a stay order. Very. On behalf
What
of.
they have done, your lordship, first they have violated the order. After violating, as an
No.
afterthought, they have filed an IA.
No, my lord.
No, it appears to be one, at least
My lord,
it is discernible from the
87
communication.
page.
uh,
87 of
page,
the advertisement.
Page 18.
87, man.
Page 18.
87.
1 minute. 1 minute. There is no harm if he is absorbed to make an application for his appointment as a director on deputation.
Yes.
At least the region assigned in 3, para 3,
Para 3.
that appears to be wrong.
Yes, your lordship. And the reason.
Because the post itself is on deputation.
On deputation. If I have not been absorbed, then I can definitely come. And the reason in para 4, that was urged before the court and rejected during the interim proceedings, your lordship.
What we do, we issue order in this contempt petition for notice. And we'll say, making it a
another
fixed
case-
date and tag with this.
Yeah.
Not
Another
Mr. M. Sharma. Right. Counsel for the petition. So this contempt petition is preferred, alleging disobedience to the directions made in an order dated 23/7/2025 in a petition WBC number 4027/2025. Full stop. It is submitted, it is averred that the order dated so and so was duly served upon the respondents. Full stop. And the respondents had also, after being aware of the direction, had issued letters, dated 24/7/2025, within bracket annexer A2, and dated 28/7/2025, within bracket annexer A3, which are clearly suggestive of disobeying the directions made in the order dated 23/7/2025. Full stop. Let notice be issued. Full stop. Notice is made returnable. You take also by Dusty 22/9/2025. Steps by registered post with AD in addition as per for Dusty compliance affidavit. This case along with WBC number 4047/2025. It would live hard Mr. KP Pathak, learned counsel for the petitioner. Mr. Any settlement counsel? Mr. AK Doctor, learned counsel for the Standing Counsel, LZBRIMH, for the respondent number 225, full stop. Peruzda, office note, dated 28/2025. Full stop. Await for the service reports in respect of respondent number 6 and 7. Full stop. The other respondents make never to file their counter affidavit on or before 22/9/2025. List the case on 22/7/2025 along with contempt case number so and so. The interim order pass side shall continue. That has made infractions. In the next date of listing. If any, huh? Did you challenge the order passing penalty of censure in this repetition?
In the inquiry report, nothing was found against it. Kindly case one. Conclusion of the inquiry report.
Then we have to issue notice.
My learned friend, because there is a process to think there is a for to the next practice. Earlier I was deprived. Again, there is a delay, I again be deprived. Because already one incumbent Lina Das, her position in the gradation list of inspector of taxes was much below me. But she has been promoted as the superintendent of taxes.
So infliction of penalty is a bar.
No, because this
Infliction of penalty, say at what point of time it was inflicted?
Penalty was
Inflicted
14
when?
page 17, 14/11/2024.
Page.
Page 67.
67. Yes, Mr.
Lordship,
Chaudhary, imposition of a penalty at an earlier point of time. Would it be a bar for authorities?
Lordship, here the penalty is given is censure for.
So is it a bar?
No, Lordship, for consideration,
For promotion?
for if she is within the zone of
Yes.
consideration, she will be considered by the authority.
So
Department.
where is the apprehension?
Lordship may kindly give an observation, Lordship, to that effect, Lordship, that there is no bar. And Lordship, the person behind this all this thing, Lordship, he has been arrested just 3 days back, Lordship.
It is for you to.
Yes, additional commissioner,
It
Lordship.
is for you to bring authorities on it.
This additional commissioner of income tax, he has been arrested. CM vigilance has raided his.
That is subject matter of appeal and thereafter of the writ petition. We cannot at the motion state decide on the penalty of censure.
No, Lordship.
Question is about your apprehension regarding that in the promotional exercise in the offing.
Okay.
You have an apprehension that your case might not be considered, right? Though you are in the zone of consideration. For that, otherwise legally there is nothing because there is no bar.
Lordship may kindly give an observation to that effect, Lordship.
But Lordship may kindly see his prayer, there is no prayer for with regard to the promotion. Only
Yes,
for
yes,
regularization of his suspension
Yes,
period
yes,
areas, multiple prayers are there, Lordship.
Lordship may kindly see my prayer. Plus page number 19, my prayer 5. Roman 5.
But that is at the stage of final consideration.
No, No, my learned friend has said that I have no prayer. I have not made a prayer.
Lordship,
Read
multiple,
the rest of
there
the
has to be
mandamus
regularization
to
of his
restore-
suspension period and everything.
To restore her
Leave
traditional
period.
belief and promote her to the next promotional post of superintendent of taxes. That prayer is very much there.
Whether this DPC has been
DPC
constituted.
Before conclusion of the DPC, I have been reinstated in service.
No, DPC, I am saying. DPC,
Yes.
not DP. Whether DPC has been constituted, anything has been moved.
No.
Every issue is interconnected. You
Because
cannot
Lordship-
separate it from one
I-
prayer to other.
Lordship, I have 215 days of earned leave to my credit. They have not.
This,
Yes.
Mr. Das, I can understand, but this cannot be considered the motion still.
Yes, that I, but Lord-
Be
Yes.
reasonable to that.
Lordship, one observation, Lordship, that if my promotion to the next post of superintendent of taxes,
Hard.
that penalty of.
Mr. S.K. Das. You file you have got everything
Yes.
now. Now I counsel for the petitioner. Mr. B. Chaudhary, Lion Standing Counsel, Finance, within bracket Taxation Department. For
1, 2, and 3, Lordship.
the respondent number 1, 2, and 3, and Miss
And for
name, please.
arts,
Lion Standing Counsel, Accountant General, for the respondent number 4. First of the petitioner is presently serving as an inspector of taxes to which post she was selected and appointed in the year 2013. Full stop. During her service tenure, comma, a disciplinary proceeding was initiated
And lordship, my period of suspension may also. And my period of suspension may also be regularized, lordship. Obliged.
17 then.
17. Plus. Obliged.
Item 4.
May I please, Lordship. Lordship, this petition challenging the order that cancel the mutual transfer order. My lord,
One thing, this animal husbandry, they have got a separate spending council.
yeah,
Can photo.
we have no.
Name is not there in the cost list one. That is the, maybe she is not aware.
Yes.
My lord, can photo, my lord, name is not there in the cost list. That is why maybe.
But it's sub copies, sir.
Not, name notes on my.
We already sub copies. Already sub copy, my lord.
Maybe she is not aware, my lord. Name is not there.
After some time, my lord, that I may call him. Yeah.
I haven't seen that question, but.
Item number 5.
Mr. Chaudhary is appearing, my lord. He didn't late. And that will be possible for the time being.
Item 6.
Wait, please, Lordship. Lordship, can this matter be taken after some time? Mr. Nayak is going to appear in this case. He's on next, my lord. What number?
In that case, your lordship, may I pay the matter will be fixed day after tomorrow, your lordship. I have some urgency. I have to leave, your lordship. Yes, your lordship. I think day after tomorrow, your lordship. Yes. Really obliged.
Item 7.
May it please your lordship. Matter relates to compassionate appointment, lordship. Petitioner approached earlier, lordship, before this court.
Very recently, one new OM has come up. Yes.
Yes, lordship. Lordship,
As far as I see, lordship, here, no, it's a bench matter. It's a
lordship,
bench matter because he was working in police. Ultimately, SLC reject, but the thing is that lordship, a new OM has come up, dated 30 August 2025, where in point number 2, it has been stated that cases where rejection of applications for compassionate appointment has not been set aside by any court, or cases wherein such rejection has not been put to challenge prior to 4/4/2025 shall not be reopened unless there is specific direction from the court. Now, this case has been filed in the month of June 2025. And Lordship, I have sent a copy of the OM to the email of the court, Lordship. Basically, Lordship, there are 3/4, Lordship. All the matters which challenge the OAM and prior to 3/4 of 2025 ordered a single court because all the matter has been streamlined and been sent to the government to take a decision. So the government said we will decide as per merits, as per the procedure. Yes, so 3/4/2025. WBC number.
342.
In 3/4/2025.
It's a series of.
Yes.
From 67 minutes. Yes, yes.
And after that, only.
Minor was out of the bench.
And after 3/4/25, if any there is new cases filed. Like suppose 4/4/2025, and all these cases, this OM, only the OM will be covered. I mean, the compensation pension scheme will be covered. Whatever cases will file after.
And I think August 2000.
But
See,
this case has, yes.
August 2015. Right?
Yes,
And by September 2015. Then DLC was held 2021.
ultimately SLC.
That gives the kind of definition. The definition was based on November 2015. Directing the authorities to hear the case before the DLC. Invoking of the
Yes.
It was in place.
in the police.
Yes.
That's how other departments.
Yes.
Then DLC physically September 2010 recommended the case of the
For appointment.
the required post of existing position.
Yes.
Yes, but no.
Yes.
September 2000. Then it was forwarded to the commission, education department. Basically, the next SLC or harder. Then this office now the.
Yes.
2024. In.
Yes.
So. That has become. The family. The real.
Yes. Yes, Lordship.
What has been done there?
On although Lordship had the GLC recommended, but SLC. Yes, sir. From Lloyd, it's a refuse to consider.
DLC recovery.
Place on.
No, SLC recovery, DLC recovery. But we can mention it, but when it's 18. SLC.
Oh, yes, not rejected by any authority.
Pending.
So, the thing is that ought to be placed, but at that time ought to be placed before the SLC, but that was not been done in COVID. Because
Lordship, page 31, start from page 31. And relevant page is 34, Lordship. Serial number 1. Top, Lordship. Diksha Dev.
so then Lordship, then in that case, directly Lordship that democratic body judgment will apply. Yeah, I understand, Lordship. There is not a question of challenge of OM or any. But otherwise delay is there, that is fundamentally it has been reflected from the.
And
CPS program. No, not, this is 1, 2, 3, and 6 and 7.
I don't know, I'm hearing three pages. Three pages, that's what number 4 and 5. Yes, 5. 4 and 5.
Obliged.
Item 8.
So can this matter be taken up after some time? Senior counsel is a key should really clear, obliged.
Item number 9.
May Peter Lordship. This case is regarding promotion, my lord. Lordship may kindly come to page 20, my lord. From the post of my lord, senior assistant to head assistant. May I read this letter, my lord? With reference, with due respect, I have the honor to forward herewith one number of application in respect of so and so under the disposal of the Joint Director, Vishwanath, Assam for promotion to the post of head assistant. At present, head assistant post has been lying vacant under this establishment since a long time. Currently, Sunundo Khan, senior assistant, has been looking after the work of head assistant in the office of the Joint Director, so and so. Right, order date. The ACR of the last 3 years, that is 2022, 23, 24, medical certificate, seniority duty roster list, and graduation list for your ready reference. Lordship may kindly come to the next page, madam. But serial number 1 is the petitioner, petitioner. Madam. But serial number 1 is the petitioner, and serial number 2 is the private respondent. The private respondent, madam, he joined on 2018 as LDA, and I joined on 2013. Thereafter, madam, I took over the search of UD assistant on 2022 January. Madam, private respondent took over the search on September 2022. Now, my lord, before that, madam, Lordship may kindly see the last order, madam. Imperial order. Yes, madam. He has been allowed to take over the search of his assistant, madam. But this order has to be stayed, madam. He is junior to me, madam. 24, madam. Yes, madam. Thereafter, madam. Lordship may give him some observation, madam. Four. My lord, 4, my lord. Advertisement. My director is advertisement 2. I stay of the engine order. Lordship, in the meantime, my lord, they will start the process for promotion as per this letter, my lord, their own letter, my lord. And under the annexure, my lord, annexure 4, my lord. Let them start the process, my lord. My lord, okay.
17 then. Item 10.
My lord, issue involved in this case, my lord, regarding whether, my lord, criminal proceeding and the departmental proceeding, the same subject matter will be go together or not. That issue is already, my lord, several writ petitions are taken together, and these are already placed before, my lord. Here in this case, my lord, the petitioner is a police constable, and there is a FIR filed against him, against her, my lord, and he was arrested and he was put under suspension. After that, my lord, he was so cause notice was served on him in the departmental proceeding was started in the same subject matter and same set of allegation and same set of witness matter. So, my lord, already, my lord, see then that issue, my lord, already near about 20 petitions were taken together. Not same case, my lord, same issue, my lord, same point. Whether the issue same but not department different, my lord. And these are another order, my lord, which are taken together. That yes, case are not same. Some cases are same, but not all same. All are not same. My lord. Against the petitioner, my lord, one FIR was lodged, my lord. Anti-corruption case was registered. FIR, my lord, your lordship will find at page 21 is the vernacular, my lord. 21, my lord. May I read it, my lord? Translation is there, my lord. Translation is page 18, my lord. Page 18, my lord. Yes, step was yes, then accordingly she was arrested and she was put behind the bar, and she got the bail was allowed. And after that, a show cause notice was issued, my lord. And my suspension order is page 28, my lord, Annex D. Page 28. My lord, due to arrest, my lord. Then I was released on bail, my lord. And I was served with a show cause notice, that is page 32, Annex F. I replied, my lord, your lordship kindly say the allegation, my lord. While you are posted as a Gauripur PS, you are arrested by the Vigilance and Anti-Corruption Brigade in illegal bribe money of fraud, Utpal Chandra Roy. Initiated, my lord. So now, my lord, I want that, my lord, that if I disclose because that now, my lord, issue notice to me, my lord, I have to appear and I have to record my statement, my lord, and that evidence will be taken, my lord. So if I disclose my evidence, my lord, so it will be seriously prejudice in my criminal case, my lord. So that is why your lordship kindly see that my order dated 4/10/2024 in another case.
I think a batch of cases, some part of some inquiry.
Yes. 30.
This case is different, one lordship.
No, your lordship kindly see, my lord. I am not completed, my lord. Your lordship kindly see the last but 3 paragraph, page, 3rd page, my lord. That 2nd page, my lord. The issues involved in the instant batch of writ petitions are preliminary 2 categories. As your lordship got in, my lord. 2 categories. Category 1, legality and validity of the report dated so and so submitted by the one-man commission of the inquiry and all consequential effect thereto. And category B, challenge to the simultaneous continuation of disciplinary proceeding and criminal trial. So we are in category B. So now, my lord, this honorable court passed an order to categorize, my lord, to separate them category 1 and category B. So
Discuss.
my lord.
14, they have discussed. All the judgments have been discussed regarding that.
My lord. So since, my lord, there is nobody, but if it is in the same set of allegation and same evidence, then, my lord, it will.
Unless very complicated and complex issues call for consideration.
But since, my lord, no, because if my lord, no, your lordship kindly see, my lord, and then your lordship kindly next week fix, my lord, I will argue because it will have the effect in that case also. That's B. That's B, my lord.
Not filling powder or whatever.
My lord, no, my lord. But that same order witness here also, my lord, in the departmental proceeding, my lord. Yes.
But to that judgment also.
My lord.
Because here I have seen reference to 2014 judgment.
14 judgment, my lord.
That might have been considered, and again a new proposition of law will.
No, why I am placing this today, my lord, because already that court has taken that view of this honorable court. That's why I am placed before your lordship. Because, my lord, that category B, the same question, my lord. Same question. My lord. But your lordship, that means, my lord. My lord. My lord.
That there is a complete bar. Proceed with the departmental procedure.
My lord.
That is the law issue.
My lord. That is the
Same set of facts.
same set of facts and same set of evidence.
That's why I say, let us have a proper.
My lord. Not in this week, my lord. Next week, my lord, any date, your lordship fix, my lord, I will let you know.
Because if I'm finding it that it is an issue, any of the.
Yes, my lord.
Let me have a also proper
Really?
as an issue, because I have said it is bad for us.
Correct. Probably this batch B matters are probably listed on Friday, maybe. No, that is last. That last it was listed in category B. So let me next week any date, my lord. Monday, my lord.
Yes, Lord.
My lord.
Here, one thing is noticeable, lordship, prosecution is yet to started because charge sheet has not yet been filed. Yes, lordship.
My lord. Deeply.
Different.
Item 11.
Maybe the lordship. Lordship, this matter also relates to lordship completion appointment. Here, lordship, my father was expired in the year 2008 lordship. And I applied lordship in the 2009 lordship within 1 year lordship. Later lordship, my application was forwarded lordship. The authority lordship may kindly see page 35 lordship. It was in time lordship. Therefore, in course, of course, lordship, I also approached before the Honorable High Court earlier lordship. And High Court also lordship passed an order to consider my case lordship. In between lordship, some communication was lordship, only some communication was there lordship. Later lordship in the year 2023, I got yes.
Pilot will just. My lord, page number 62. This is very vital. 62. This is a minor of the meeting of the district level committee, my lord, the BTC.
Yes.
Not BTC, my lord, Commissioner Appointment. Deputy Commissioner, my lord. If you go down below serial number 4, my lord.
Yes,
The
my
writ
part.
petitioner, my lord. Nadjari. Here, my lord, we are very categorical. The application was submitted on 22/8/17, but the government servant had died in 2008. The application was submitted after a long gap of 9 years after the death of such and such.
Yes.
And the application in respect of this matter cannot be considered by DLC due to delay.
Lordship, data said that is fully wrong, Lordship, because Lordship, there is official commission, Lordship, I applied in time, Lordship. But they said that I have applied in after 29 years. Lordship. Lordship.
My lord is fixing it on.
22nd 9, 22nd September.
My lord.
Oh, yes, Lordship.
One, two, three, four, seven, eight. 4, 7, 8. 8.
4, 5, and 6. 5 and 6.
My lord, that make an observation, my lord, that my submission, my lord, it state of West Bengal versus Deborah Tiwari, it clearly covers, my lord, this piece.
I think how well.
May I please, Lordship? Here, my lord, one petitioner before our Lordship, my lord. He has challenged the order passed by a DLR, my lord. On my lord. My lord. Selection, yes, my lord, 2023, my lord. My lord, challenge said I have filed the appeal before the district DLR, my lord, Director of Land Record, my lord. On 3 ground that he is a political person. I am from Gaubra family, and selection board which was constituted is illegal in violation of section 162(2) of the executive instruction, my lord. Thereafter, my lord, the DLR, my lord, earlier DLR, my lord, he has heard the matter thoroughly, all scrutinized. Thereafter, my lord, he has transferred. New DLR has come. We expected that he will heard afresh and pass a previous order. But without hearing, he has passed this order, my lord. Here, my lord, I have selected. Then at this stage, issue.
Thank you. Four and five.
Agree board, if I say, if Gaur.
$162,200. Two. He is an active member of political party. Political party. And thirdly, malapetition of being the son of retired earlier Gaukura, that has not been considered. Yes. Which hasn't become. The will be subject to. Will subject. My lord. Yes. Yes. It is up to your lordship. High levels.
Item 13.
May I please, your lordship? The petitioner herein is an unmarried daughter of late Aftabuddin. Yes. I'm Arshadi.
For aspirant number 226, Suresh.
I have a training question. Yes.
Dependent of the or it is part of what is from the
Deeply obliged.
Item 16.
May I please, your lordship? Lordship, this matter pertains to reinstatement in service, lordship. Lordship, the petitioner here was lordship, he was suspended in the year 2023, 2023. No review, lordship. No periodic review. And lordship, his retirement is due on 2027.
No, Lordship, I'm appealing for 3, 4, and 5. One is to be represented by the rating.
PP Gogoi.
was subsequently released on the like 2000. Where like very
Deeply obliged, Lord.
Blinding matters, I don't know for.
May I please, Your Lordship? So this is a mutual transfer, like both of them, my lord, under the animal husbandry veterinary department. My lord, one is of course working, my lord, at the, my lord, directorate office, and another one, my lord, is in the district office, Dorong, my lord. Now there's a similar, there was a transfer policy, my lord, mutual transfer policy, page 27 is the policy, my lord. Well, they both of them were
They are not appointed as per this scheme. Also, they are not belongs to this scheme. Also, no, this the initial transfer SOP was prepared also, and they are not belongs to these new rules. Also.
page 20, page 27, my lord. Our, my lord, the three conditions that will be in the same grades pay, my lord, covered by the same service rule, and the nature and qualification both are similar. Both all are similar, my lord. And my lord, page 29, district office to directorate office transfer is permissible, my lord. Tick mark is given, allowed or not. District office to directorate office of so and so, my lord. Accordingly, it was allowed also, my lord. And one of them even joined. Petition number 1 join. Impugn order is page, my lord, 38, my lord.
38, Lordship, it is categorically stated that it has been observed that the said transfer order.
Yes, my lord. 3.B, my lord. Yes, covered under the same service rule.
Lordship, instruction may be required. Lordship, today my name is not shown, Lordship. Therefore, I am not equipped with the instruction, Lordship. Instruction may be required, Lordship.
District office.
Not, Lordship. Lordship. Then. Yes. Not covered?
Madam.
Standing counsel. Annual has been given. Veterinary department. University. Of the office environment, one of application that something yeah.
Well, Assam Directorate Establishment, Ministerial Service Rules 1973, man. They don't have any separate service rules for the department. This post, my lord.
Assam Directorate Establishment, Ministerial Service Rules.
73, that's.
That's all I'm saying. Need any extra copy?
Lordship. Well, sir, finish, my lord.
Tuesday next week.
Well, 9-9, well, can you be some other 9 and some difficulties? 10.
I don't know, 5.
May it please your lordship. Lord, it's a very peculiar case, my lord. What had happened, there is an order, if your lordship would kindly come to, it starts at 47. Please come to page 55 of that order, my lord. Now, our cause of action, my lord, is derived from this judgment. I'm sorry, page 56. Yes, my lord. For the reasons stated herein above, this court is of the opinion that the impugn order of dismissal from service dated 14/12/23 is vitiated by arbitrariness and illegality. The same is accordingly set aside. Consequently, the writ petitioner shall be reinstated back in service forthwith. However, having regard to the peculiar facts and circumstances of the case and nature of the allegation brought against the petitioner, this court is of the opinion that the fact of the case do not justify exoneration of the petitioner on such technical ground without subjecting him to proper inquiry proceeding. As such, department is granted liberty to initiate a fresh proceeding against the petitioner from the stage of issuing upon the petitioner to explain his conduct. If such an explanation to be furnished by the petitioner is found to be unsatisfactory, it will be open for the disciplinary authority to draw up a disciplinary proceeding against him as per law. Since the petitioner is due for retirement from service, this is not relevant. Now, this court recorded a finding, my lord, because earlier, based on some inquiry conducted by the deputy commissioner, he was sought to be punished. Therefore, the court was of the view that you give him an explanation. To that, he will file a reply. Based on that, you will derive your satisfaction whether it is a fit case to go for a DP or not. Now, that was directed by this honorable court. But they have not done that, my lord. Now, what they have done now, they have issued again a show cause notice at page 71. Page 71 does not reflect, my lord, whether the reply dated 3/7/25, which was submitted by the petitioner to the explanation called for on 27/6/25, was at all considered. My lord, pursuant to the order, my lord, the earlier show cause notice was withdrawn Then a letter was issued on 27/6/2005 at page 66.
In between, there was another.
Yes, that is also gone. This is to inform you that a letter number so and so received from the Deputy Commissioner Nalbari regarding inquiry report relating to SBMG under Nalbari district, and wherein it was alleged that while functioning as Executive Engineer Nalbari Division during implementation of Swachh Bharat Mission in Nalbari district, you have willfully and knowingly authorized payment of 6 false and fraudulent bills amounting to rupees 34 lakhs in favor of so and so in 2 tranches, one in 6 lakhs, other in 28.2 lakhs, without due verification, thereby misappropriating large government fund. You have also failed to ensure so and so claims to have been constructed by Messrs. Hems Society were actually constructed by the NGO. In view above, you are hereby asked to explain as to why disciplinary action should not be initiated against you for misappropriation of the government money. So, my lord, in terms of the order of the learned single judge, my lord, this explanation was issued. Now, to that, I replied at page 67. I'm not troubling our lordships with the merit of the allegations, my lord. Our case is very simple. Now, if your lordship kindly comes to page 71. You are hereby asked to show cause under Rule 9 of the Assam so and so, read with Article so and so, why any of. Now they have initiated a DP against me. Now, where is that order, my lord, whereby my explanation was considered, it was found to be unsatisfactory, and hence the disciplinary authority had taken the call to go for disciplinary proceeding? Am I not entitled to know at least, my lord? So at least prima facie, this order does not reflect anything. Now, in any case, my lord, can there be a second inquiry? There could be a further inquiry. Now you can't, my lord. Earlier there was an inquiry. Set aside. No, what I am saying. E.
The inquiry is pending.
No, inquiry.
Inquiry is not set.
My lord, when the interim, when this punishment order was set aside, naturally everything goes, my lord. No, my lord, perhaps, my lord.
Stage of issuing notice.
Yes. From the stage of issuing notice, my lord, the same set of people would be there. Now the show cause notice would be issued after recording a satisfaction that your explanation is not satisfactory. Therefore, authority will proceed. Now, in the process, yes. That's why I said, my lord, it's a very peculiar case. Yes. There could be. Yes.
Thereafter, authority reaches satisfaction on the case, we can drop this or we can proceed.
My lord, in my humble understanding, there is no such requirement. But there is an order. That order has attained finality.
Why spend up 16 and trying to understand.
Yes. My lord, what?
That is for one, you will extend the requirement.
Yes. My lord, yes, paragraph 16 in essence. Yes. Yes. No. A notice asking for explanation, not a show cause notice within the meaning of Rule 9.
I have to step into the shoes of, so it is my somewhat difficult or transparent. If it is notice, then explanation. And definitely a show cause notice is the next thing.
Yes.
If he reaches a satisfaction, then
Yes.
the same proceeding is to be
Initiated. Yes. But then naturally, then that is even permitted. That is mandated also.
So that notice asking.
Yes.
apply in mind.
To the reply filed by the, to the explanation. Yes.
That is the understanding.
That is what is perhaps intended in para 16 and 17. Yes. I may read it once again, Milord. Now 17 qualifies, Milord. It further fortifies the position. If such explanation to be furnished by the writ petitioner is found to be unsatisfactory, it will be open for the disciplinary authority to draw up a disciplinary proceeding against him as per law. I'm reading 17, Milord. Okay. As such, department is granted liberty, fresh proceeding against the petitioner from the stage of issuing notice upon the petitioner to explain his conduct. Milord, that the expression fresh proceeding has been loosely used, but if we read it 16 and 17 harmoniously, Milord, what follows is, before proceeding under Rule 9, what is mandated is you issue an explanation, call for an answer, apply your mind. If you find it is satisfactory, well and good. If you find it is unsatisfactory, they can proceed.
Yes, Mr. Sakshi, I agree with this proposition.
Yes, ma'am. Absolutely, my lord.
And yes, I agree.
Yes, my lord. Just to add one thing, my lord, with greatest respect, my lord, this has happened because of this paragraph 16. Because under the rules, my lord, there is no such provision to give an explanation. It is up to the discretion of the authorities to give us explanation letter or not. But here, my lord, the Honorable Single Judge, my lord, has directed to issue a notice for explanation. Initially, my lord, that we constitute that to be a departmental proceeding under Rule 9. So we issued show cause notice. Then they put that to challenge. They're saying that explanation has to precede this notice, show cause notice. Then we decided that we'll withdraw our show cause notice.
So by his conduct, the petition this is
explanation.
Notice for explanation.
Yes. So that is why my lord produces page 64, my lord. That is the earlier repetition filed in between, my lord. Therein, my lord, they contended that show cause notice cannot be issued since show cause notice is to be preceded by an explanation, which we have not done. So this repetition, my lord, we decided that we'll withdraw the show cause notice. We have withdrawn.
What is the comprehensive say the second?
Second repetition is that this explanation part was not complied with. Because we constitute that to be paragraph 16, that to be section Rule 9 says, my lord.
Rule 9.
So we issued a show cause notice, regular show cause. That was challenged, saying that explanation was not preceding.
So by his conduct,
He accepted that, my lord. Yes.
that there is an explanation required.
Yes. So
And you reach.
yes. Yes. So the Honorable Single will submit before Honorable Single. Okay, we'll go with the explanation first, then if necessary, as per paragraph 16, my lord. If it is found to be unsatisfactory, then we'll go for DP. So we issued an explanation to him. The petitioner submitted his explanation. Then it was processed, my lord.
So what is the missing link?
Missing link is that, my lord. They, if I may submit.
The relative point unfriend complete. The missing link is, my lord, I as a petitioner having obtained an order from this honorable court, and this honorable court specifically directs that ask for explanation, then proceed. Now, am I not entitled to, my lord, what is the outcome of that exercise before you decide proceed to issue notice under Rule 9? That is my case, my lord. My lord, for a moment we are assailing the decision making. Nobody is disputing the power of the employer to initiate a DP in an appropriate case.
Yes, ma'am. We have the records, ma'am. We'll indicate that, ma'am.
Yes, yes.
Application of
Mine. Yes.
That is one of the essential.
Absolutely, absolutely, absolutely.
To proceed. So that is why I say that.
Produce the records.
But the passing of a speaking order is pertinent or not, that is a different issue. But application of mine to the materials placed before him, that means the notice and explanation provided. And application of mine. That is what I found most essential.
Yes.
For to proceed or not to proceed. Whether there was application of mine.
By the appointing authority.
Appointing authority or disciplinary authority. And second is whether that speaking order is essential or not, that is another issue.
Can you finish that record now?
No, my lord, anyway.
Because this is an area where
Yes.
there, if you can place some authority.
My lord, the speaking order normally is not necessary, but in the facts of this case, it is necessary. No, my lord, I'll give one more example, my lord. Supposing there is a preliminary inquiry. There is no requirement of associating the delinquent in the preliminary inquiry. The whole idea is to gather information or materials, whether there are materials to proceed. Now, only when, my lord, the preliminary inquiry report is used in the disciplinary proceeding, then it can be used, provided in the preliminary inquiry report, delinquent was a part. Otherwise, my lord, the preliminary inquiry report cannot be used in the disciplinary proceeding. So therefore, that's why I said, my lord, it's a very peculiar case where there is no requirement of associating a delinquent with a preliminary inquiry. In effect, by saying that you issue a so-called explanation, consider the reply is something, Lord, that on preliminary gather facts which stood gathered, on that we are calling for an explanation. That is not a sine qua non. But having said so, my lord, but in this case, this honorable court has specifically said, and in para 17, my lord, it was qualified. Therefore, it is a case where, in my humble submission, my lord, at least I am entitled to know the reason why my explanations are not acceptable. If I know the reason, then only I can challenge. Because the requirement of a valid notice is what, my lord? The charges must be definite. The delinquent must know the reason why the explanation has been rejected. Then only I can challenge. If I am deprived of the reasons, then, my lord, I have been deprived of making an effective writ petition before this honorable court.
Well, the kindly page 4, madam. It is a part of the record, madam. It's a still file, madam. You get printouts. This is how, madam, the authorities applied their mind. It says, madam, to Sri Avtar Singh, Superintendent Engineer PHC Hailakandi Circular submitted his written statement that is so in response to the explanation from so. Sri Singh has stated, these are his, my lord, contention. These 6 contentions. Next page, my lord. After paragraph 6, he has denied the allegation of knowingly authorizing the fraudulent bill. Now, if the authority finds the explanation to be unsatisfactory, request departmental proceeding, duty may perhaps be initiated against Sri Singh, taking into consideration that all the procedures are adhered to and to carefully. Then, my lord, may kindly skip to page 10. In fact, in between, my lord, they wanted a legal opinion from me. I opine, my lord, that I cannot give a view whether its reply is satisfactory or not, because it is the role of the authorities to take a call. Then page 10, my lord, this is by the secretary, the disciplinary authority. Page 10, note 74. Avtar Singh has submitted a 17-point reply against the explanation call issued to him. Though he has denied the causes of explanation, his reply is found to be unsatisfactory. He could not justify regarding the payment of false and fraudulent bills submitted in favor of Ames Society. He also failed to justify on the claim that the IHSL were actually constructed by Ames Society. Therefore, DP may be initiated against him now by issuing show cause. Following this, the show cause notice impugned was issued, my lord. So, in respect of a, my lord, stays, which is not contemplated under the rules, my lord, application of mine or, my lord, everything was taken care of. If we, my lord, now come back to paragraph 16 of the judgment, my lord. Page 56 of the requisition.
Mr. Chaudhary, do you want to see?
No, my lord, while my learned friend was reading, I could get it, my lord. Now, my only submission is, my lord, whether an enforceable right has accrued to me in view of para 16 and 17. That is the only point, my lord. Yes, I agree with my learned friend. Normally, it is not required. That 100% I'll say it also, my lord. But question is, there is a specific direction. Therefore, my lord, assuming they say they are not satisfied, I'm entitled to challenge that reason. So now they having said, I should be given an opportunity to challenge this also along with this petition, my lord. Whether the reasons are sustainable. It would be an extension only of the earlier order, nothing beyond, not otherwise. So I should be given an opportunity of assailing the reasons, my lord. Now, whether your lordship will be agreeing with our reasoning or not, that's a different thing. But technically, my lord, I am entitled to put to challenge the reasons. Because it is the outcome of a judicial exercise.
Paragraph 16. Last sentence. As such, the department is granted liberty to initiate a fresh proceeding against the petitioner from the stage of issuing notice upon the petitioner to explain his conduct. With greatest respect, my lord, the Honorable Single Judge considered giving an explanation and replying to the explanation is a part of the proceeding. But that is not mandated under Rule 9 of the Disciplinary Appeal Rules. Now turning to the next page, my lord. If such explanation to be furnished by the petitioner is found to be unsatisfactory, it will be open for the disciplinary authority to draw up a disciplinary proceeding against him as per law. Since the petitioner is due for retirement from service with effect from February 26, it is made clear that whatever proceeding is to be initiated against the petitioner by the disciplinary authority, the same shall be conducted in a period of 6 months from so and so, with effect from 1/3/2025. So, my lord, again and again, petitioner is filing case, probably to my lord over to complete that 6 months of period. That is what I think, my lord, may not be correct. Now, my lord, it says, paragraph 17, first line I will read again, my lord. If such explanation to be furnished by the petitioner is found to be unsatisfactory, it will be open for the disciplinary authority to draw up a disciplinary proceeding against him as per law. So, my lord, nowhere in this order, neither at paragraph 16 or 17, it says that our application of mine is to be informed to the petitioner. More so, my lord, in respect of a stage, my lord, which is not contemplated under rules. If now my lord decides that no, you have to communicate your reasons for disagreeing, then my lord will be actually inserting a clause in Rule 9, my lord, for all time to come. For all time to come. That was a part of safeguard granted to the petitioner, but that safeguard cannot be elevated to the status of Rule 9, my lord.
Initially, I thought that it is notice means fresh proceeding.
No, my lord.
In fact, initially I thought so cause notice.
My lord will kindly read para 18 also, my lord.
Explanation.
Para 18 is further explained, my lord. Para 18 from the sentence, however, since this court has granted liberty to the disciplinary authority to initiate a fresh process by serving notice upon the petitioner to explain his conduct, and if the same is found to be unsatisfactory, then only departmental proceeding be initiated against him.
We have found that to be unsatisfactory and we are proceeding now.
Now, what is the drawing up or initiation of departmental proceeding when it is stated?
My lord, going by that 1991, Venkataraman, Janaki Raman's case, when a show cause notice is served in a departmental proceeding, then it's initiated. And similarly, in a criminal case, when charge memo, final report is submitted.
In the pension rules also.
And the pension rules also.
So in this case, my lord, we have applied our mind, that stage of explanation, my lord, we have complied with. As my lord has rightly pointed out, my lord, we initially also thought that this proceeding means Rule 9 proceeding. That's why we issued a so-called. And interestingly, my lord, the second repetition was again listed before Honorable, same Honorable Judge, my lord. That time I also pointed out, then Honorable Justice Mr. Sam indicated me that you have to comply with this. May not be contemplated under the rules, since we have already passed an order, you have to comply with it. That's why, my lord, I wrote a letter to the government to withdraw the earlier so-called. Then it was cancelled, my lord.
Okay.
My lord, first final reply, my lord. Article 14 and natural justice, my lord, both sides of the same coin. End of the day, on the strength of the judicial order of this honorable court, all that I am expecting is a reason as to why my explanation has been rejected, which will enable them to initiate a DP under invoking Rule 9.
Okay.
This honorable court has not prevented them from proceeding. All that I am trying to read in that order is, my lord, a requirement of communicating so that I can also put a challenge to it. For example, I'll just say one thing, my lord. Recently, a lot of eviction matters are going on in this state. On an earlier occasion, when the Supreme Court was dealing with the matter, the Supreme Court said, all right, you give them individually notices, deal with them, pass an order. If the order is unfavorable, then they should be given an opportunity to, make appeal or
Arrangement
the
for-
authority. These provisions are not incorporated in Rule 18. So these are all safeguards, my lord. End of the day, These are safeguards meant for, my lord, preserving the liberty of the citizens.
Yes,
That's all.
Mr. Chaudhary and Mr. Goswami, because I have to enter into the minds of we issue notice returnable on Thursday,
Thursday, my lord.
this Thursday, and we take the other file also, dispose of second file. Not the first one, whereby the judgment is already rendered. Let us see the contention by the petitioner. Thereafter, we'll decide this notice and explanation and requirement of passing a speaking order. That is the only issue.
My lord, can it be on Friday, my lord?
Friday.
My only anxiety,
Friday only will dispose of.
Only anxiety is that the first order say it has to be concluded by 6 months. That my lord may take care of it. The main DP matter. We concluded.
Second inquiry, what about
6 months from 1st of March.
We'll take care of that.
Yeah, exactly. Let me do that.
We'll take care of that on Friday. Because matter was sub judice all this time.
Yes.
Also,
Okay.
on Friday, my lord.
Okay. What is the next petition?
The in between repetition was my lord. WPC number 3475.
Yes.
2025.
Heard Mr. K.N. Chaudhary, Land Senior Counsel. Stated by Mr. D.N. Padasari, Land Counsel for the petitioner. And Mr. P.N. Goswami, Land Additional Advocate General. Stated by Mr. K.P. Pathak, Land Counsel for all the respondents. Full stop. And order. Sorry. A show cause notice dated 30/7/2025 has been put to challenge on the ground that the directions made in paragraph 16 and 17. 16 to 18 of a judgment and order dated 27/2025, passed in WBC number 2211/2024, have not been complied with prior to issuance of the so cause notice dated so and so. Post of it is noticed that during the period between the judgment and order dated so and so and the so cause notice dated so and so, the petitioner preferred another repetition. WBC number 3 4 7/5 2025, which was disposed of on 26/6/2025. Full stop. They are providing these documents will suffice or they need?
I think they can provide that note, my lord.
That I have already submitted.
Dilani. Oh, no, yes, given.
I did all kinds of digital.
They are not, they are maintaining verbally. Oh, sorry, digitally.
Digitally. No, that I've seen.
Okay. As let notice be issued as the counsel for the parties have expressed urgency. Notice is made returnable Friday. The case record of WBC number 3475/2025 is to be tagged with the case record of this case. Post of. You need copy, no? You need copy, no?
Copy of my
Repetition?
that I have.
Oh, list the case on Friday. The other second case, repetition?
Yes,
Let us see your contentions raised there. Begin 20.
next. Okay. Number 8. My lord, here Lordship would like to issue notice, my lord, and tag with the other case, my lord. Other case is 3807 of 23. For order to be another. That's another. As a notice. Notice is for other. Well, that's the order passed in the other case.
CPF to ZPF.
Yes. CP.
Heard Mr. Kane Chaudhary, Land Senior Counsel, estate by Mr. A. Das, Land Counsel for the petitioner, Mr. R.P. Kakoti, Land Standing Counsel and Senior Counsel for the respondent number 2, 3, 2, 3, 5, and 6. Also heard Miss for the respondent number 1 and 4. Full stop. The petitioner is aggrieved by non-transfer of her contributory provident fund cum gratuity scheme account to general provident fund cum gratuity cum pension scheme.
Yes.
First of you should notice that counsel for the parties have submitted that another petition of the petitioner WPC number 3807/2023 is pending as on date, and this petition can be tagged with WPC number 3807/2022. Issue notice returnable in 4 weeks as assisted by Mr.
Yes.
S.
Sudhar.
Yeah, Sutradhar, as Mr. Sutradhar. And Miss has appeared and accepted notice on behalf of so-and-so and Miss so-and-so, Miss Pukan. Central Government Council has entered accepted notice on behalf of so-and-so. Issuance of formal notice is dispensed with. Extra copies you need 2 working days. Place the case after 4 weeks along with WBC number so-and-so.
Deep learning.
What? How do you mean?
Number 17, correct, please.
Matter is whether the writ petition is infructuous or not. Is submission that the writ petition has in fact become infructuous because the DG's report under section 26(3) has been issued. I believe received as well.
I am also not because reason is that the order passed by the one was a challenge, legality and validity. Now your lordship has not granted that thereafter they are proceeding. But that does not mean, my lord, that the writ petition has become infructuous. Assuming, my lord, after argument, my lord, that is allowed. All proceedings will be, my lord, set aside. How it can be said, my lord, that the order, the report which has been submitted, that will make the petition to be infructuous.
Then we have to hear it.
The petition needs to be heard. This is, and the petitioner is not saying infructuous. The respondent is saying infructuous.
Okay. It is his submission. I have accepted.
My lord,
So, in my respectful submission, Your Honor, may I kindly have order dated 28/6/2023. I'm relying on this. So I will sail and sink with this order. 28/6/2023. Your Honor, may I have para 29. And permit me to read this paragraph. That is the sum and substance of my case. This is a decision passed by this honorable court where it's been held. If there is, Your Honor has the para 29. If there is ground for presuming that the contravention of the provisions of Section 3 of the Competition Act in the nature of bid rigging or collusive bidding has occurred, the Commission can definitely form an opinion that a prima facie case exists. The word presume means to take as proved until evidence to the contrary is forthcoming. It is on the basis of materials on record, the Commission could come to the conclusion that bid rigging or collusive bidding is a probable consequence. Cannot be said that there is no basis for the Commission to form an opinion as regards existence of a prima facie case. Having gone through the contents of the information and the details of the 4 tender processes floated in the year 2013, 15, 17, and 18, and the prices rates quoted by the opposite parties for oil well cement, OWC, in those 4 tender processes for various destinations across India, despite their manufacturing facilities at different places in India, which have been well tabulated in the information as well as the impugned order dated 18/11/2020. This court is not persuaded to accept the contention of the petitioner that there exists no prima facie case for the Commission to issue a direction that Section 26(1) of the Competition Act to the Director General to initiate an investigation. The order dated 18/12/2020 passed by the Commission is found to have been passed with well-recorded reasons, which are with reference to the information and on basis of the materials on record, and this court has not found any good and sufficient reason to disagree with the view of the Commission regarding existence of a prima facie case. So I pause here. As far as the 26(1) order is concerned, the finding returned. Now, this finding was challenged before the learned appellate court. If the order of the appellate court is in our favor, then there's been no further challenge. So in my respectful submission, this stands settled. Now I read further. Having regard to the observations made by the Honorable Supreme Court of India in paragraph 49 in Excel Corp Care Limited Supra about the relevant facts qua the information and documents sought for by the Director General from the petitioners by the notice dated 8/11/2021, because this notice is also on the challenge. And in the interest of facilitating a proper inquiry by the Director General, this court is not inclined to interfere with the operation of the notice dated 8/11/2021 at this stage. This has also been upheld. So the entire investigation now is on the basis of this paragraph at the end of the day. When this has been upheld and the Director General is rightly issued in furtherance of this notice 8/11/2021, issued the report, which is under Section 26(3), then the entire remedy will now be under Section 26 of the Competition Commission Act. Because under Section 26(3), would Your Honor have that provision?
Competition Act.
Yes, Your Honor. Section 26. I'll just read 3 provisions and I think make the scheme very clear.
Yes.
So 26(1) is where the impugned order stems from. Now, Your Honor may have subsection 3 of Section 26.
Subsection.
The Director General shall, on receipt of directions under subsection 1, submit a report on
1 minute. 26(3).
Please, Your Honor.
It starts with?
Subsection 3. The Director General shall.
Okay.
The Director General shall, on receipt of directions under subsection 1, submit a report on his findings within such period as may be specified by the Commission. This has now been done, and this is what was put to challenge and decided in my favor in the order that I just read. Now, Your Honor may have the next subsection, which is 4. The Commission may forward a copy of the report referred to in subsection 3 and 3B to the parties concerned. This has also taken place. Now I come to subsection 8. This is important. Oh, 5, Your Honor. First 5. If the report of the Director General referred to in subsections 3 and 3B recommends that there is no contravention of the provisions of this Act, the Commission shall invite objections or suggestions from the central government or the state government or the statutory authority or the parties concerned, as the case may be, on such report of the Director General. So this is one course of action that may happen. The alternative course of action is under 8. If the report of the Director General referred to in subsection 3 and 3B recommends that there is contravention of any of the provisions of this Act, and the Commission is of the opinion that the further inquiry is called for, it shall inquire into such contravention in accordance with the provisions of this Act. So there's actually an entire mechanism where a hearing will take place, and that is where the fact finding will take place. Because there's evidence to be led to see whether there is actual contravention of the or not, whether there was bid rigging, whether there was price parallelism. So these aspects will have to be seen over there. In view of the fact that this entire process has been was a sale but sustained, and then the challenge was not carried forward, now it's final. Now, I would respectfully say that in view of the fact that the report has now come, the remedies lie before the Commission. They're not being condemned unheard. They will have the full, the entire scheme of the Act is with them. Because this court cannot go into the, my respectful submission is that under 226, the powers of this court to get into the evidence may not be appropriate.
The observations by your lordship. Now, at this stage, your lordship, after issued notice, that the interim order will not be, and against that refusal for the passing of the interim order, the appeal was preferred, and the signing of the interim order was complete. Now, my learned friend is saying that the report has come. I give you, for example, 482 file. For your lordship, is notice everything. The stay is not gone. Proceeds. Cash it file. That the 482 stage after hearing, also finds that the materials are not there. Pass it. The lordship said that no, you go to the trial court, everything will be there. After that, you can proceed, but whatever is there.
Okay, proceed for hearing then.
I'm the matter.
I agree to it.
One repetition has already been allowed. 126.1, that is better of they file an appeal before the revision bench. That's why your lordship will not adjourn the hearing, that let the outcome be. And how they are harmed. They may proceed. They may go on proceeding without whatever they want to do. But in case assuming without after 2 months hearing, it will cost, everything will cost. They're not stopping them from proceeding, they can proceed.
Okay, let us hear this repeat now then. A matter of
one submission here.
2022, can hear it. Can proceed for the hearing.
My only submission is that in the other case that's being referred to, there is no DG report there. Here, there is a DG report.
Yes, correct. I agree. The DG report is not there. But the DG report is existence. DG report doesn't make any difference. So far,
you agree to that.
Very well, Your Honor.
I would also perhaps like to have a look at the report. May have a bearing, the report.
No bearing.
Look at if required on the
report.
Whatever, if you want to bring something on record, you can on record.
Why they are taking the opportunity to argue for lordship so that I can try whatever possible is there. It is right. How they are harmed? They are not harmed in any way because their proceedings are not state.
No, I come back to para 29. Because in para 29, the sum and substance of that order is that the proceedings will continue.
It is an interim order. It is an order on interim prayer.
Very well.
Finally. That tentative view, that is not the final view.
Your lordship would not have issued notice. Thereafter, the petition would have been dismissed.
Because we heard it on the interim prayer. That is the basic premise on which this petition was listed initially. Right? Before me. Otherwise, there was previously it was proceeded with another court.
The lordship not this object, lordship not have issued notice also, lordship would have dismissed it.
Yes.
But that was
because it was on the interim prayer.
Interim prayer, Lord.
So we can proceed.
Very well.
There may be distinction with the other case.
Yes, they can make.
Which is pending before
the division bench.
Distinction. All distinction makes
Everybody
the order not
big
binding.
difference. Distinction or they want to make any
The
other.
coordinate bands does not make it binding for the other one. Because
So
you have the distinction that that judgment is not binding because of this
And
distinction.
we are not only
It's
relying
possible
on
to
that,
have-
we are not relying only on that judgment. That is only a come as a further, my lord, assistance to us.
Okay. Fine.
Very well. After the puja vacation,
Let them proceed. Whatever they want to. They have no objection.
Agree on a date then.
I,
Not in the first week.
not my agreeing the date will not do anything because ASG is
16th.
deputy, so ultimately the convenience of his will come.
I'll just seek instruction.
You'll also may
And
fix up a date, my lord. And thereafter, my lord, on that day, convenience, etc. After 10 days, my lord.
We'll put it on 15th October.
Thereafter,
16th, my lord, on a Thursday.
So that you agree on a date
Very well, my lord, 15th.
thereafter.
on 15th, they can agree the date as per the convenience. We are here, my lord, there is no problem.
We are ready on that date, then we.
No, not that way, we are ready or not. First day you say that we are ready or not. We're not preparing that way.
Then we can put it on 24th September.
My lord,
Very well. That'll be. better.
24th of September, my lord.
Just for
For the date.
agree on-
Date, not-
for agreeing to a date.
Your
of
lordship,
hearing.
mention for,
Or if your honor may give me half an hour, I'll instructions on the date and indicate it.
no, let it be date, my lord. Thereafter, let me inform you also. We have to also see. In the full liberty because AG appearing, but that doesn't mean that.
Not at all,
convenience.
sir.
Then,
Absolutely take your consent.
Dr. Paraf. As senior counsel. Mr. Student counsel for the petition. Mr. Didas, current counsel for the response to it. And Mr. B. Churri, current counsel for the counsel for the parties submitted that. To be sit on 20,000. Submission in advance on behalf of the subject matter of the litigation has not become infractious, as submitted by the learned counsel for the response. In such view of the matter is the case on 24/9/2025. So, court will proceed. Here, ready. Learn. The date then, that day. I think this is the understanding you will suggest a date. Because I think this case is specifically assigned to me, so it will be listed before me only. I don't know whether I'll be sitting in principal seat or not.
whenever your lordship sit,
Whether I'll sit in the principal seat or not, that is, I'm not.
so
sure.
whether the division bench and all those things, that has to be seen as per the roster.
So otherwise 24/9.
Very
well.
And this is a matter which cannot be hard in virtual.
Absolutely.
Take
It is.
time, because in the interim stage also it will lot of time. I'm highly obliged.
24/9.
Item 18.
Is appointed for the post of ASA supervisor. Here in this case, what happened?
Petitioners are ASA,
Supervisors.
ASA supervisors.
Supervisor. They were. Yes, my lord, what happened on 2010-2008 at an XRA was issued for advertisement was issued for appointment of ASA supervisor. Here, criteria was against every 10 ASA workers, there will be one supervisor.
Every 10.
Every 10. There will be one ASA supervisor, and in that way, my lord, in this particular area, there ought to have been '29 or 30. In that
Their ASA supervisor or their experience of ASA supervisor?
No, they were selected as ASA supervisors. And what happened? In the process of selection, in that particular district, there are some anomalies in the selection, and that's why the selection process was stopped. And Honorable Court Milord has directed that there will be fresh selection in that case. Accordingly, final selection was
You
made.
said 2008, there was an advertisement.
There
There was an advertisement, right? Then what had happened to that advertisement?
in other areas, Milord, that was fulfilled. Appointments were made accordingly.
Right.
But in that
We are discussing which one? Or which area?
at page 24, you will also find
No, page 2019 is first advertisement, 2008.
Yes.
These are ASA appointment selection for ASA supervisor.
Yes.
Right? Then there is another advertisement, page 20, 2015.
No, that will come later. That is my bone of contention in the case.
Okay.
At page 24, you are also find at serial number 39,
24.
page 24, serial number 39, to read Hajarikandi. There, post available is 28. Vacancy also 28. 28 persons were to be filled up. But somehow the election process was challenged and the election can be finalized during that period. Now it is best election was made, Milord, and by page 30, Annexure F, they have appointed only 15. Basing on the order dated D at page 28, order dated 25/1/2022 of the government. Here, what they have done, according to some notification, they have now said that there will be one ASA supervisor against 20 ASAs. Previously, it was against, in the advertisement, it was against 10 ASAs. At page 19, you also can see. So my contention is that when game has already started, the process has begun, cannot be changed in between. Rules cannot be changed in. And appointments should have been for 28 posts only, and not 40. Not 15 as has been done by order 2/3/2020.
Mr. Solia,
My lord.
come to page 19.
Yes,
This is an advertisement.
yes.
That is, you said 2008. Now, there is another advertisement to page 20.
That is true. What at Milord I am telling that since it was originally began in 2008.
Could be,
Yes.
but what is this advertisement? Which one is acted upon? Because here it is, online applications are invited.
They cannot act upon this advertisement
Why?
because since game has already started, according to Supreme Court decisions, Your Lordship is aware. It
So,
cannot be changed.
game
in
has
between.
started, but yet has not proceeded.
No. In other case, already that is done.
Then why this 2015? Because see, online applications are invited. And completely there is a criteria. Implement changes guidelines for conducting interview and selection of ASA supervisor. A new set of guidelines have come in.
No, that I'm telling you, not that cannot be done in between. Because the original one was 2008. Kazari Kandi was there, Milord, and Kazari Kandi not be filled up, Milord. All these 28%. Because of the
Orders of the
complication section.
Now, what
They
is
were
this?
high-
What is this order? 2863 2015. WBC 2863 2015.
Yeah, that I have incorporated, Milord, in an IA.
IA. IA.
IA 3212.24. That I referred to, Milord, I could not put the order.
IA.
One, two.
W 2005 2015.
Yes, yes. No, 4410. Yes, is.
But come to page 2025. Oh, sorry, page 25. Please come to.
My lord.
Please come to 25. Page 25 of the repetition.
Oh. Yes, 25.
Please read with reference to, because there is reference. Order of the Honorable Guwahati High Court in WBC 2860 2025 dated 2005 2015.
Yes.
Now read the content. Read the content.
Yes. As to subjects, I hereby interview prizes candidate as per order by candidates who had right engagement advertisement that you're also in between.
Yes, where is that order? Do you have that order?
Same question.
There were subsequent against this getting
Then, 2008 advertisement, there were shortlisted candidates.
yes. That was challenged
Yeah.
earlier and
So the petitioners were among the shortlisted candidates.
my lord.
Then what is the two-tier process, interview
There
and?
was interview level, then at the director's.
Okay.
That was not suggested, and the Honorable Court has said that that is not wrong, that is wrong. Done by this. That page, para 30. In view of this supported discussion, subject to
Page?
IA 12, 3212.
IA.
First judgment is
First judgment, para?
4401. WPC 4401 or 2009.
Para?
Para 32 has directed. Honorable Court has directed of the report. Forwarded by the of the director as well as the by the state level in respect of Gazarikandi block are also set aside. Affected block based by interview who had applied for engagement as a supervisor. 2010-8.
And what was the selection process as per the advertisement of 2008?
That was considered by this court, Milon, and after
Which para? Which para?
examining the records, court found that was not proper.
No,
It does.
2015.
My lord.
2015 advertisement said that it will be, I think.
As per the advertisement dated 2008.
What is the selection process as per the 2008 advertisement?
That was only district level. Court has considered this fact and has.
Which part?
In the last judgment, Milord, of the last judgment.
That has been set aside.
Yes, set aside.
That has been set aside. What is the process of selection envisaged in the 2008 advertisement? has given approval to what kind of selection process?
Court, there was 9 or
Please take me to that part.
29. Yes, ma'am.
I will put it on this Thursday. We'll take up for final consideration. This Thursday. I think we need to read this judgment because we are not getting the selection process directly. We have to read one. What is 2-tier selection? What is 3-tier selection?
Only interview. But 2-tier was that 2-tier was
Because,
by the first
because
judgment.
actual documents are not there. We have to read the judgment.
Hello.
Otherwise, and it is not a short judgment, long judgment.
Long judgment, yes.
Yes, Miss. Thursday.
Thursday.
Third Miss. Council by Miss Roy. M. Roy. And Council for Deputy. A. Boda. And Standing Council for the respondent. And Council for the parties submit. Exchange of pleading is complete. Publish the case on Thursday, huh? Post of an endeavor will be made to pick up a petition for final consideration. This Thursday.
Therefore, respond number 2.
Mr. D. Boda. He was standing counsel, Health Department, and Mr. D. Boda.
NHM.
Counsel, for the office.
Items 19 and 20.
I please your lordship. Lordship, my senior is on legs before the division bench. Kindly pass over the matter for a time being.
Development has been taken place, madam. Matter may come after.
This is the bench 5 matter.
Actually, bench 5 matter.
And is it?
Subsequent development has taken place. Matter may come after 1 week, madam.
Before appropriate bench. Before
After 1
appropriate bench, I am not taking a bench 5 roster. Yes, I decided one petition.
Yes, ma'am.
That does not make that I'll
Bench
take up
5 matter.
these cases forever.
Yes, ma'am.
P. Sinha and Council for the petitioner, Miss.
D.R. Ovang on behalf of SK Taluk.
The subsequent of the petition and contempt and the contempt petition pertain to bench 5. Resti list cases before the appropriate bench. In bracket bench 5. Bench 5, right?
Yes, bench 5.
Item 21.
Please, your lordship.
Section, my lord, pursuant to the earlier order of this honorable court is awaited. During the adjudication of the writ petition, some queries were raised by the Honorable Court. Was directed to have the instruction.
What is the matter about?
My lord, the petitioner is assailing his non-promotion from grade 4 to grade 3 post. This is the third round of it.
So many pleadings,
Yes, so.
Private respondent
Huh?
said that. Private respondent.
11 pleadings.
I am assailing on first the violation of the rules. The rules prescribe seniority. For the
And what was the instruction sought for?
Regarding the vacancy. Here, my lord, the issue regarding that educational qualification. My lord, there is a rule of 1967, where, my lord, it was prescribed initially that it will be matriculation. Pursuant to that, a notification was issued by the taxation department because we don't have any rules. That particular criteria for promotion from grade 4 to grade 3 will be applicable. Now, in 15, that rule came to be amended. Now, qualification is, my lord, graduation. But, my lord, to that effect, no notification was issued from our side. So now, my lord, they are taking a plea. In fact, the petitioner,
it is in
should
which
be
rule?
graduation.
It is in which rule?
It is the, my lord,
Pertaining to
Assam District Ministerial Rules of 1967.
57, 67.
Lordship.
And you are finance department.
Yes, sir. Yes.
So you have to adopt or it automatically applies?
That part, my lord, now is lying before the Honorable Division Bench. My lord, on a similar issue, the Honorable Court has left it to the wisdom of the department to take a call in this. That judgment I have. And that is under challenge before the Division Bench. In fact, today that matter came up. And pursuant to the liberty given by the Honorable Court in that earlier writ petition, even though the writ appeal is pending, government has taken a decision that it will be graduation. My issue will be, my lord, whether that graduation will be applicable from the date when this petition was taken, or, my lord, retrospectively from 2015. Again, that will be an issue. So that will be.
Court has not interpreted it.
That part not interpreted because it has, court has left it on
Now-
the department to call.
Decision is taken by department.
Yes, ma'am.
So it can be prospective, prima facie.
That part, that, my
If
lord,
the
that
court
issue will-
interprets it, it would have been
Yes, in fact, my
retrospective.
lord, we will be filing affidavit by tomorrow in that writ appeal. That issue will crop up.
Now, why this vacancy position was required in this
That
case?
is the other limb of my argument. That I am senior, my junior is superior.
Okay, that is Article 14.
I can just show my last page of the report. One page I will show everything. Page number 51, annexure 10 of the report.
Table might. Oh,
As a lawsuit got it. My lord, serial number 13 is private respondent number 4 here. And serial number 14 is private respondent number 5. But you will kindly come to the last column. Respect of serial number 14. He joined as peon on 2nd of October 2010. The petitioner joined as peon on 5th of February. I am 2010. Same year. He joined on October, I joined on February. Serial number 14.
Serial number 14.
Tapan Kumar.
Where are you?
My lord,
Which one is the petitioner?
I have been denied, that's why I am before.
Oh, okay.
Lordship,
Yeah, there are two
serial number 14.
two private respondents.
Yes. 14.
And your date of joining?
My date of joining is, my lord, 25th of February 2010.
Okay.
I have annexed that document.
Lordship will see 14, my lord, he was promoted on the SC category.
You are challenging 14. Serial number 14.
Yes.
Serial number 13 is in 2005 only.
Yes.
So he is senior.
Yes.
So serial number 14.
And my lord, Lordship will kindly see this one. I immediately approach this. This honorable court direct. They kept it pending. And that order, this honorable court also directed to keep one post vacant. They, my lord, during the currency of that interim order, they promoted serial number 15.
Okay.
But he has expired now, so I am not party.
Okay.
He has expired. Now, when I file a contempt, my lord, then, my lord, they can see that as per the rules, the promotion quota is over by virtue of appointment, promotion of this bill number 13 and 14. So, my lord, I was given Reverting to essay. This is how I am again.
So, this, you are challenging private respondents promotion.
First,
So if your repetition is allowed, respondent number 5 has to make way
yes,
for you.
that
No vacancy or whatever.
there's no vacancy.
Or for that reason, it was.
Yes, in fact,
instruction.
my lordship will see in the same chart, serial number 14, my lord, he is a SC candidate. No, that's why I'm saying, my lord, whether the petitioner can claim promotion in that particular post. SC. Serial 14, my lord.
So today what we have to do?
My lord, lordship will
Exchange?
give me some time, my lord, 1 week, so I will come up, my lord. In fact, the instruction for, I filed a RTI application. And in the RTI application, same instruction, I also, in the reply, same reply they have given, the reject reply they have given. Quota is 10.90 to 10, for direct recruitment is 10. There are 17.
Okay, there are lesser number of vacancies for promotion from peon to.
Yeah, as per rule, as per rule.
Only as per rule.
So, lordship, I 100.
Which one, 19/6/2025?
Yes, 19.
There's a long order. Three consecutive decisions, hat-trick. Yes, yes. Okay. Have you received instructions?
My lord, not receiving, my lord, from the petition itself, my lord, it reveals that she was the married wife and she did not get the divorce, my lord, from the from.
Yes, necessary divorce papers.
My lord, my
Whatever.
on mutual,
Divorced,
Divorce.
then there has to be a decree.
my lord,
There has to be a decree.
my lord.
Cannot be verbally. You are really married. Petitioner is unable to provide any divorce.
One,
It is not of the.
That cannot be. More particularly, Rojomoy Das, Prochomoy Das. Who is that? Your father,
other,
Prochomoy Das. So there has to divorce. Then why should we proceed for last 2022? Have not been able to produce any. No point,
There's only that
just for the purpose of docket. If you come across, then how can it be then? How can it be? It has to be, the word is clear, divorce. And divorce can be by dissolution of marriage, by a decree of divorce. Mere claim will not do. There has to be some decree. Otherwise, everybody will come, I'm divorced.
on the basis of some deed, my lord, they are claiming.
Huh?
On the basis of some
Deed will
deed.
not do.
Yes, my lord.
These deed, registered deed, unregistered, then thereafter, after getting the pension, you can withdraw the deed very privately again. Right? Agreement can be made, thereafter, on the same day, it can be cancelled also by another deed. That is not possible. We'll close for the timing. If you come across any good document, Mr. J. Law School, Learned Counsel for the petitioner, and Mr. J. Gavin, Learned Central Government Counsel. Where is the provision? Otherwise,
One is in case.
Learned Central Government Counsel for all the respondents. The petitioner has preferred the instant repetition, claiming family pension on the ground that the petitioner is the divorced daughter of the pensioner. Post of Para, the Government of India in the Ministry of Defense framed a policy dated 17/11/2017, laying down that divorced daughters, a divorced daughter of a pensioner who fulfill the conditions prescribed therein would be eligible for family pension if a decree of divorce had been issued by the competent court during the lifetime of at least one of the parents. So the petitioner in this writ petition has claimed pension on the ground that the petitioner is a divorced daughter of the pensioner, late Rohomoy Das. The petitioner has not annexed any degree of competent court to support such claim. Mr. Loskal and counsel for the petitioner has submitted that this petition may be closed at this stage, reserving liberty to the petitioner to approach the court with better particulars. So Ms. Egayon Learned Government stepping for the response that has not the submission made by Mr. In view of the above submission made by the petition, the writ is closed at this stage. However, liberty is considered to the petitioner to approach to seek appropriate remedy with better particular under the law.
Item number 23.
Yes, Mr. Paul. Oral submission. Yes.
They file it.
They file affidavit.
No, you know. First letter.
Huh?
When they amended. affidavit.
Respondent number 4 was struck off.
Related, stuck off.
Yes.
In the last
Who, other respondents? Other respondents. What is your prayer here?
that is that, my lord, of my yellow pay,
Huh?
basic
Basics.
was my lord, my son promoted
Okay.
already.
Yes. The respondent.
Lordship, there's many respondents, your lordship. I have just instructed and they had actually short time,
How much time?
4 weeks time may be granted.
Okay, RC Paul, Land Counsel for the petitioners is present. And,
I'm applying for respondent number 1. Daily.
and who is the main respondents?
5 to 15, I have 5 to 15. The many departments,
3,
5 to 15,
5 to
5 to 15.
Oh, different districts.
Yes,
Malak,
same district, different
Different,
branches.
not the same.
Anyway, if
Mr. A. Fukon,
One.
Standing Council EAD for the respondent number 1 and 3. Arborwood. Finance 2. Mr. D. Bora. Correct. For the respondent number 5. Oh, Treasury which Treasury officer Arbor Treasury. আৰু বাকি কি দি পৰা 21 to বাদ দিওঁ. Who is this 21?
Private respondent.
Private.
Yeah.
Served. Notice served.
Service.
Okay. Mr. Bora, Junior American, appealing for respondent number 1. Has prayed for and is granted for time filed. Counter affidavit on behalf of the.
Immediately after.
You are enjoying all you are one salary, higher salary, that's all. You can survive. You get the money at trans.
We got this money also.
That will serve better purpose
Immediately
after 4 weeks.
24. That's 5. On land acquisition.
Huh?
Hence 5, land acquisition.
Why it has come?
But is that for last 3 dates for your lordship? Not a matter of part hurdle.
Oh.
This one I can.
And this is because after 1 month, nothing remains part.
It is unreasonable, yes.
On many occasions, lordship, there has been, but ultimately for decision. That have one particular part of the case I have to submit.
Some other hand. It was in February. This is by lapse of time has gone out by the notification. It should be before proper bench.
Lordship.
Mr. Talukdar? It should be before appropriate bench. Should be not to be treated as part of. L. Talukdar, Learning Council for the Mr. R.M. Das. Standing Council 2.5. Who is revenue as Doctor Revenue 4 and State Council Mr. D. CKS Borua 1, 3 and 6. Here's the case for it bench. In bracket bench 5. Bench 5, right?
Lordship.
Bench. The matter be treated as part of. As the counsel for the petitioner has expressed urgency, raised it to less the case, preferably in the next.
Numbers 25 to 34.
Yes.
Yes, my lord. Lordship. Really, person have an advertisement. 90.
Lordship,
Filed all the-
similar set of writ petitions are tagged together, Lordship. So I pray that the matter also be tagged to the same. These are fixed
It
on
appears
16.
they all are tech.
No, there are
Separate.
other matters also. Number of matters.
Already 25, item number 25
Yes, Lordship.
to 34
34.
are tagged already.
Yes, my lord.
There are other sets of writ petition, Lord.
Huh.
Been heard by.
Similar issue or different issue?
Similar, Lord.
Yes, similar
Otherwise,
matters, Lordship.
fixed
Where
on-
Don't,
Advocate General
the
is
main
a-
issue is similar on law, okay, we'll tag.
Yes,
Otherwise,
Lordship.
don't jumble up. Yes, Mr. Khatuni, what do you say? You are a petitioner in other batch also?
No, my lord, I'm not the other batch of writ
Now, what is the subject matter here?
regarding my pursuant to the advertisement, we have responded, my lord. They've been selected. Thereafter, my lord, they have constituted a medical board. Assess our stability, my lord. Not permission under the issue.
And you claimed selection on the basis of disability.
Disability.
Okay.
After.
Interim orders are operating in some of them. And other, for a post, what?
Different post, my lord.
No, what, let us see the advertisement.
Yes, my lord. Advertisement is 86, my lord.
Okay, recruitment for different posts of grade 3 reserved for persons with disabilities. So the process itself is for
Yes, my lord.
disabled person.
Yes, my lord.
And
Only for a disabled
the other batch also is,
Same, Lord.
Same. Percentage of disability.
the issue is same, that
Issues are same, Lord.
medical board should not be
Yes,
considered.
Lordship. Lord.
Whether we can constitute medical board to accept the this once they have already been identified by the competent authority.
Okay, yeah, having that
Certificate.
certificate
of this.
or identity card or whatever.
Yes, my lord.
That is the issue. And
Writ petition number 2,
and
3, 0.
main respondents have filed their counter.
In this batch of writ petition, my lord, not filed.
In the other one,
Yes, Lord. Fine.
that will suffice.
Lordship, there's a common affidavit
Okay,
has been
good
filed,
enough then.
Lordship.
Let me take it, my
Then,
lord, because I have
first-
gone through that.
What can we do? We can take this matter along with the other matter before vacation. Then if
I think
you can have
These are-
the consolidated affidavit file in the other batch, a copy, go through it.
Yes,
If it is okay with you, then we can proceed. Yes?
On 16th, Lordship, the matters are fixed.
Before whom? Any hard?
There's a-
Hard heard?
No, not part heard.
Okay, then we'll put it on 16 days.
Yes,
Okay. Tell me one case number.
2301 of 2000
Decoction. 2301.
of 2000.
Okay. Mr. Okay, you give the names whoever is appearing. Yes, sheet of paper for the petitioners. For the petitioners. And for the petitioners. And Ms. M. Bhattacharya and additional senior government advocate. And who else? Government advocate, any government counsel? Mr. J.K. Goswami. Mr. J.K. Goswami, land standing, any animal, veterinary and animal husbandry. D. Pomonno, land
Yes,
standing counsel,
Health and Family Welfare.
Health and Family Welfare Department. Ms. P. R. Mohanto, land standing counsel, Higher Education Department. Ms. M. D. Bora, land Transport Department, land standing counsel, Transport Department. This is the P.J. Fukon, standing counsel. You are also part of this advertisement. Huh? Electing authority. Okay. Standing counsel, Guwahati Department for the official respondents. Yes. Miss? Or you are standing counsel?
Social Justice Department.
Social Justice Department for the official respondent present. The learned counsel for the parties have submitted that another batch of writ petition, WPC number so and so and others involving similar issues, are also pending as the those involved in this batch of are similar. With them, this repetition may be listed along with the other batch of repeat, WBC number so and others on 16/10/2025. It is submitted by the counsel for the respondent that a consolidated affidavit has already been filed in the other batch of repeat, and the said counter affidavit might suffice in this might suffice petition. So be that as it post of list this batch of it along with the other batch of petition, W and others on 6.
What is the deadline?
Interim orders, wherever passed, shall continue till the next. 16/9.
35.
Yes, Mr. Soikia. Affidavit is filed. Reply file. And what is the prayer?
First title,
Okay, what is the prayer?
my lord, the grievance of the petitioner is that they are getting lesser of lesser
Yes,
basic
madam.
structure of salary, my lord.
Today is also filed. Filed on 1 to,
Okay.
but the newly their instruction.
Newly implemented respondent.
Yeah, 8, 9, 10 has the last order, lordship.
Okay. Newly implemented. Who are they? Who are they? Newly implemented respondents?
Special diet-
My lord,
Ah,
still director,
respond number?
respondent 8, 9 and
8, 9, and 10. And notice issued for them.
no, my lord.
Huh?
Complete.
So, for time. When did you implement? By IA?
Yes, yes,
No, I can't give. IA to IA.
I ordered it.
M. Soikia, Learned Counsel for the petitioner. And Ms. L. Devi, Central Government Counsel for the respondent number 1, 2. 7 are present. First up by an order dated 22/8/2025. Casting IA Civil number 2747. So 2020. Respondent number 8 to respondent number 10 have been newly implemented post. Let notice be issued to respondent number 8, 10. So the note made returnable in 4 weeks as Ms. Devi. Then it's has appeared and accepted this. We have one number 8 to the formal extra copy. Respondent number 8 to 10 may file their response to the writ petition within honor or before the returnable date, if so advised. This is the case.
Item 36.
May I please?
Yes.
Yes. Changes, special order.
Reading is complete.
Lordship may wait for.
Put it on a hearing date then. It is pleading is complete. Heard Mr. M. Mohanto, counsel for the petition, and Miss
And they
M.
Ardha.
M.
And they
and they on behalf of
Ardha.
R.
Ardha.
Hor. And counsel representing Mr. R. Hor. And standing counsel, which department?
Public work.
Public Works Department for all the respondents. The counsel for the parties has submit the exchange of pleading complete. This case for for a hearing on after vacation. Yes, on a hearing date.
23rd of
Third.
Item 37.
Yes.
Page number 23, man. Petition was appointed peon, man.
23.
23, my lord, was appointed as a peon, the Department of Sericulture. 23, my lord. Now, Lord, kindly page the pin 20. 20. Of computer diploma certificate 5.
Yes.
Computer diploma, man. Page number 20. 20. Thereafter, my lord, after complete 10 years in service, man, he wrote to the department at page number 29. 29. He wrote to the department that he had completed 10 years in, but computer diploma was not included in the lesson list. At 29. Further, I would like to inform that I am a graduate in diploma in computer and seek promotion from grade 3. Thereafter, my lord, the department finalized the gradation list at page number 38. At serial number 88, my lord. In the educational qualification, my lord, only A was met. Computer diploma was not met. His only grievance is that, my lord, let the department verify his educational qualification regarding computer, modify gradation list, my lord. Computer diploma along with his qualification. That much. Is the
Yes, madam.
30.
Or. Okay, this is your only limited. Okay, next week then. On the kind of penalty of present. Okay, here's the Islamic Council Board of Petitioner is Miss N. N. Day, Council President. Mr. Ardhor, the Training Council. PWD.
Sericulture.
Agriculture Department has made a prayer for adjourn. Prayer for adjourn. Sorry. Place the case on switch with it next week. On the earlier date, he made an objection for adjournment.
Because we did not file a rejoinder.
7.
7. Value.
38.
May it please your lord.
Yes.
Related to my promotion.
Promotion.
Things completed, my lord. Actually matters very not a matter, my lord. I am working the Deputy General Manager HR. Now my next promotion is, my lord, General Manager HR. So already my name has been recommended by DPC the year 2023, and till today I have not been appointed on a very flimsy gown. In fact, my lord, I have in my writ petition, I have all the gown I have stated why they have not in. In fact, they admitted their affidavit. Matter is, my lord, pending. Because of, my lord, case is pending, why they have not been. Only my promotion.
Yes, Ms. Fukan, you represent whom?
Yes, I filed my, I have mentioned for, in one word, I am that is for restructuring organization, by spending.
The structure is not bearing any disease case, my lord. In a very flimsy gown, my lord, they have pending. Very flimsy
I
gown.
mentioned in paragraph number, I can read you.
Paragraph number?
6.
Running page?
109.
Paragraph 6.
Yes. Yes, yeah.
Your so-called organizational restructuring has completed or not?
Not complete.
Huh?
Not complete.
What kind of organizational
That is
structure?
no bearing in this case.
Hmm?
There is no bearing effect on that, my lord. Why others are being promoted, those who are in the same DPC, my lord.
No, there is any.
Non-cadre post.
Huh?
Our post is non-cadre post and
Cadre
others are cadre post. I have
Cadre
received further instruction also, Lordship.
Why her post is not cadre post?
She is from HR
The
department.
cadre post.
No, non-cadre.
This act says, my lord.
Her post is non-cadre.
Nowhere stated that is in.
Your Lordship can go through this, Your Lordship, their reply.
Post or what? Post.
In our affidavit also, 105, there we have mentioned, she is a common cadre post.
Huh?
In our affidavit also. This is the instruction regarding their reply, Your Lordship. They have filed their reply. Against that reply, I have received.
You have obtained this?
Yes.
It's a cadre of his own. Your lordship kindly see the rules, my lord. Your lordship kindly, my lord, in fact, my lord, their affidavit, they has everything they have admitted, my lord. I'll place, my lord. If your lordship allow, my lord, I'll place, my lord. Because my case was, my DPC has recommended my name. Along with others, my lord, others are promoted. Why not this, my lord? I do not know, my lord.
Others are from engineering, sir.
No,
Engineering cadre.
Your lordship kindly see page 40.
Affidavit and whatever your.
Yes, I'll file additional.
This reply, if new things are really being noted, then you can put it this in affidavit, if there are new things. As per rules.
As per rule, my lord, rule it is a cadre post. Your lordship kindly see once look into page 43.
Which page?
Page 43 of my report.
Page 40.
Some three rule
Three.
service.
Yes.
Humanly so service will have a cadre of its own in the following category. Thus other posts to be specified the company from time to time. Assistant manager HR, deputy manager HR, assistant general manager HR, general manager HR, general manager HR. Now I am deputy general manager HR. Next is general matter is, sir. Now, my lord, clause 7, recruitment. Post, in case of the post of assistant manager is direct recruitment. Now, my lord, your lordship kindly see page 45, my page 45. Page 45, in case of post of general manager is, sir. Page 45, my lord, see, lordship. The cadre strength of general manager is, sir, shall be put up by way of permission from the post of deputy general manager is, sir, who have completed minimum 3 years of satisfactory and
We
continuous
have
service.
never denied, dear lordship, that thing we have never denied.
Then,
But just because of restructuring of the organization, that's why we.
This
we are-
reply, that reply found to be completely uncalled for. There is a complete different set of rules. It is governed by different set of rules. Assam AEGCL, Human Resource Service Rules, and you are referring to engineering service rules.
From engineering, so they are promoted, your lordship.
no, now, my lord,
But if
actually,
DPC has been held or not.
hold, my lord, that is there, your lordship,
Held.
recommendation, my lord. In their
Our
affidavit,
name has been recommended, but not yet approved, your lordship.
So how this can be your pretext? That is a non-cadre post.
He is comparing himself with David Pathari, one person.
that's,
Leave aside whether post of GM is we filled up or not filled
my
up.
lord, they are
Yes.
fill uping from, my lord, in charge basis, basis.
Vacancy is available.
Yes, my lord, your lordship kindly see the DPC 125, page 125.
The vacancy is available.
Available, my lord, but that is, my lord, fill up by Thoe, my lord, in
So
charge.
take up if you don't want to file in response.
not
Otherwise,
comparing with
you place
anyone,
it,
but-
you place it before this court. That's all. You can do it. You can do the exercise today, not possible. Some
My lord,
hearing.
then your lordship kindly sought, because
Oh,
your lordship
God.
kindly see my recommendation 2023, and till today I am not getting permission, my lord.
We put it on 18 September.
My lord. No.
Exchange of pleading is complete. If you want to place this, I'll record so that you can place it. You want to file in the form of which
Since
you
he
file.
has compared himself with
No,
one.
no, I am not compared with
Another
same
person.
DPC.
Let us leave aside the
That is
comparison.
not the, that is,
If
that is,
lordship allows, then I will file, your lord.
my lord,
if
that is
lordship
not
allows to
applicable
file
to
my
me, my lord. That is not applicable to me, my lord. Same DPC is sent to, it is an another wing, my lord. But that is in case of then it is done.
Senior by Ms. P. Sharma. For the petitioner, Ms. Fukan signing off. AEGCL for the response number 3. Mr. Borua, you are there. Mr. TKS board. For the response. And why revenue, sir? Wrong. Wrongly. Pukon, you are for
1 to 6.
2 to 6.
Sorry, 2 to 6.
2 to 6. Right. Exchange of party is the key. 18-9 admission. Yeah, on a hearing that.
Fine.
On a hearing. Is not, sir, possible some other day. Want to it on Wednesday?
Wednesday, can it be taken on
Friday.
Friday?
Friday. Because I have to try that. Yes, sir. Shock like a petition. Not are present. What has happened to writ appeal?
Writ appeal notice has been issued.
Or condonation?
The delay con.
That is it in respect of what?
The order dated 29/10/24, by which the Lanark court has directed us to complete the departmental in 1 month. Against that order,
Hold on.
Lots.
Okay.
I'll apprise.
The case, no? Friday, no?
Friday.
Interim order. Past Friday. Shall continue. interim order. Our pick. Yes, GAD. Invariably.
My lord, we have filed an affidavit, my lord.
File.
Yeah, file.
File.
He has received.
Oh,
We filed, and my lord, actually it should come in CB2, my lord. Because the person who's concerned, he's a employee of the, my lord, the education department. Education department.
Okay.
CB2, my lord.
Mr.
Eldeka.
Eldeka petitioner. Epukon, Planning Council GAD, and Ms. Sharma Alliance State Council are present, and council for the parties have submitted. The subject matter of this pertains to bench registry. And thereafter is the yes approved. Yes. You file your counter
No, your lordship. Should allow some time, your lordship.
because it was expected returnable 6 weeks. And Sarkar, petitioner. 36 years of service.
Yes, ma'am. Continue.
Who is for EHE? You are for?
I am for Dimahasa, your lordship.
Okay, Dimahasa. Tarem Leka, and it's Planning Council EHAC. Are present. Ms. Teka. Has sought for. And is granted. How much?
6,
3?
your lord.
Okay, I give you 3 weeks.
Yes, sir.
3 weeks time to file. Affidavit on behalf of the respondent, EHAC AC authorities. You are for? CKS. Junior government advocate for the respondent. Whereas the respondent on Learner Standing Council, PHE department is found absent to them. The respondent authority, the PHE department are also granted 2 weeks time to file their. Is the case.
Item number 42.
Yes, rate pay. Who are the respondents? Department? State? Finance? All finance? Somebody from finance? Names are shown.
Yes, madam.
Mr. M. K. Mishra, Learned Counsel for the petition. Present. None has appeared for the respondent. Finance Department Authority. First of, in regard to a subject of grant of debt pay. And counter affidavit, the response, Finance Department Authority appears necessary. Finance Department, the respondent, authority in the Finance Department are granted.
Here we have to file an affidavit, my lord.
Honorable was sending a finance for all. So I get a you, subject matter, I get a you. Yes, necessary. Mr. Board President has sought for and granted time in exchange file counter if it appraisal is the case. File counter rate pay.
Yes, sir. Also, he has accommodated me for 3 weeks. Well,
Item 43.
Yes,
Lordship, may I appear as last order, Lord?
notice when issued.
Notice
Notice issued.
Yes,
That
Your Lordship.
lady
Your Lordship.
has entered appearance or not?
Yes, they have appeared.
They have appeared.
Yes, Your Lordship.
Mr. Bora, private respondent.
On the
Okay.
last occasion, some instruction was sought.
Where is public health
PHC.
engineering department?
So
We have not found. They are conspicuously absent today before this court.
Oh,
Oh,
yes,
Mr. Gogoi has come. In an earlier one or two cases also.
Well,
You have already recorded your absence.
I was on a bereavement, so I have to.
Okay. No, today.
Today, my lord.
You have released the pension in favor of the third wife, according to the petitioner. She is the first wife.
This issue has to be addressed by the Karbi Anglong Autonomous Council. It's defu.
They are also conspicuously absent.
I'll inform them, my lord. Next day we can take it up.
Let them come because it is wife versus wife.
Yes, my lord.
Where is?
I'll just try to bring him.
Right now, Vasily.
No, it was Dima Hasav.
This is?
Karbi Anglong Autonomous Council.
Karbi Anglong.
Lordship grants me some time, I can bring them.
Already disbursed, so let them come up with a affidavit.
What's the
You
private
file your
affidavit?
affidavit
Yes,
also,
yes, Lordship.
whether you are first wife, second wife or third wife.
Your Lordship, it's already been declared, Your Lordship, by the.
Declared?
Yes, Your
By
Lordship.
court?
Yes, Your Lordship.
Oh.
In Testament appeal, Your Lordship.
Okay.
I'll file my affidavit.
S.
The last
Diffusa
second, they have also sought time to file affidavit.
for a
but they-
petitioner. E. Gogoi. Standing counsel. It is a transferred subject.
Transfer subject.
Okay. Public Health Engineering Department for the response number 1, 2.
1 and 2.
Mr. B.P. Bora. Counsel for the response number 5. The Standing Council. Karbi Anglong Autonomous Council.
Has not been a part.
It is a party.
Oh, not there. They are not there.
They are not
Mr.
there.
No, man.
Gogoi and Standing Council. H. E
They made a
department
party-
has submitted that. Huh?
Secretary Karbi Anglong must be. Party.
He's not there.
Not
Not
there.
there.
They have not been party, Your. They
Mr.
made a
Go-
department,
has submitted that. The public health engineering is a transfer subject.
Transfer.
And therefore, the Karbi Anglong Autonomous Council is a necessary party respondent in view of the issue involved. This repeat. Mr. Diffusal and Council for the petitioner has submitted that he file an amended cost terms of within 3 working days from today. This is the case after a week.
To take up
Item number?
W.
Yes.
Petitioner, he worked as assistant forest my was placed under suspension and ordered it 7 of the
Page 22. Page 20.
trial of the departmental proceed Nepal Chandra Mondal, AFS Eastern Forest, or they were placed under suspension. Quarters was allowance allowed to insurance. Then your lordship, it was interfered with by the order dated, Your Lordship, or 24/7/2024, Annexure F is 6. Lordship, other chair, judgment. 40. As already observed as per the law laid down honorable court and also by the District Court done for
Para?
para 12. As already observed as per the law laid down by the honorable review done for extending the suspension beyond the period of 90 days cannot the employer the legal obligations cast upon them. The order of suspension dated 37 to accordingly in February. The petition is directed to be studied itself. The posting order should punish. At this stage, Sri Thakur, the line standing counsel for the department, reiterated the seriousness and gravity of the offense. Considering the above, while the suspension the authorities are at liberty to post a petition. Sensitive. His father made clear that this order direct revocation of the suspension will not in any way affect the ongoing proceeding in accordance with law. Then he was reinstated back into service, my lord. Lordship, Annexure H, page 40.
Yes.
Was reinstated, posting was given in some other, like, under Solidpur SF, the effect from Kocha. While the matter was so situated, my lord, the petitioner submitted his joining report. He was again placed under suspension by the order dated, my lord, 23/2025. Annexure J, page 47, 40. Order. Whereas Sri Nepal Chandra Mondal, AFF, then Eastern Conjure Forest, Nagaon Division was arrested on the Directorate of Vigilance and Anti-Corruption, Assam, for demanding and accept right money amounting to 8,000. Whereas the Nepal Chandra Mondal was suspended by the department's order. Based on the correspondence received from the PCC, whereas prosecution sanction was ordered Nepal Chandra Mondal by the order. Based on the report, along with the certified copy of the documents that say the Superintendent Police Vigilance and Anti-Corruption. Whereas as per provisional rule 94 of Assam, services an appeal 94. Devindan Suman IFS was appointed as inquiry officer to inquire into the charges framed against the Nepal Chandra Mondal by no was appointed as a presenting officer to present the case in support of article charges for the inquiry office. Meanwhile, the charge officer has federation W 247/2000 praying for reinstatement on the primary ground that the review extending the suspension order was done beyond the period of 9. The Honorable Court passed the judgment on 24, directing for his reinstatement and in compliance thereof. The delinquent was reinstated service by notice without prejudice the department proceeding. Whereas the inquiry officer submitted lordship report. Inquiry officer submitted the inquiry report by letter so. Whereas the disciplinary authority is not satisfied the findings of the inquiry officer and accordingly of the opinion that further inquiry needs to be conducted the matter under the provision of the Assam Services in view of the facts that certain vital aspects of the case have been missed in the proceeding to be properly dealt with by following due procedure and by affording full opportunity to the delinquent. Therefore, it is found essential to continue further with a deep and logical conclusion by taking into account the issue of additional charge sheet by incorporating the police report defense. Whereas prosecution sanction already been accorded by the order dated 31/2000. A prima facie case for criminal offense of illegal retention under Prevention of Corruption Act has been made out as a criminal prosecution pending the delinquent, and therefore his continuance in service under such circumstances seriously subvert discipline in the office and would be against the wider public interest. And whereas the first order suspension was revoked for a reason unconnected with the merits of the case, and by now there are sufficient evidence appearing against the delinquent employees disclosing a grave charge of corruption, misconduct, and commission of criminal offences on the part of the delinquent, and therefore his continuance in service would tarnish the image of the government and would have a negative impact on the administration. And whereas on an overall conspectus of all facts, the authorities of the opinion that it is necessary to place the delinquent under suspension. Accordingly, it is ordered that a service Apache Montreal AFS Assistant Punjab that were placed under suspension in effect until further orders, the excess of power under Rule 6.1 of Assam. Headquarters of the suspended office. Lordship order I challenge it carried by the Honorable. Lordship, they did not Lordship obey the
order?
Lordship, I filed the second case, the contempt application.
No, that has been challenged in this reply, right? That order has been challenged in this reply.
Yes.
Then remains suspended.
Lordship, my contempt application, annex please of my contempt application.
Contempt is for what? For not reinstating you. Okay, and thereafter what happened? What is the
As of date, they have.
reason for filing the second repeat?
Second, because the order of suspension is a part regarding the enquiry. I am not furnished with the order of report of enquiry as of. I don't know whether any both of this agreement is violation of ECIL judgment referring to. Nothing has been communicated of now. And they have not complied with the order of this honorable court as of now.
Suppose what is the authority for what is the authority power and jurisdiction of a disciplinary authority? Suppose he receives the inquiry report, and suppose he can go by the disciplinary inquiry report, or he may not go.
Yes.
May not agree.
My lord.
And what are the steps he required to follow according to?
Lordship, it has to be furnished to me first, or the notes of this agreement, as well as the report of the enquiry. Otherwise, it will be against the principle of natural justice. Lordship, kindly have a look at the entire justice.
Notes of the agreement. Okay, you read.
Managing Director ECIL Hyderabad and
Not
others.
you cannot read. Well, you read. Find out.
Nineteen 92. Lordship, there are 20. But the enquiry officer is ordered in the disciplinary authority, the disciplinary proceedings break into two stages. The first stage ends when the disciplinary authority arrives in its conclusion on the basis of evidence, enquiry officer's report, and the delinquent employees reply to it. The second stage begins with the disciplinary authority decides to impose penalty on the basis of its conclusion. If the disciplinary authority decides to drop the disciplinary proceeding, the second stage is not reached. While the right to represent against the findings in the report is part of the reasonable opportunity available during the first stage of the inquiry, before the disciplinary authority takes into consideration the findings of the report, the right to show cause against the penalty proposed belongs to the second stage, when the disciplinary authority has considered the findings in the report and has come to the conclusion with regard to guilt of the employees and proposes a penalty on the basis of conclusion. The first right.
I think that is still surviving that to propose the penalty, propose penalty.
I'm not aware of nothing.
No. I am asking.
My lord.
That inquiry officer submits the inquiry report.
It's apparently in my favor.
1 minute. Let us see the law, thereafter we'll apply the facts. And if the disciplinary authority, he goes through it, then he decides to accept support. Then he needs to forward a copy of the inquiry report to the delinquent. And delinquent can submit his reply, right, to the inquiry report. Thereafter, he finalizes his order, disciplinary, impose punishment, whatever. And one of particular thing that he gets the inquiry report and he is finding that ultimately, say, inquiry officer says, charge is not proved or whatever, partly proved, whatever. Not proved. He accepts the report. And it is not required he is not required to send it to the delinquent. And third one, which is the case here, that he decides not to agree with the inquiry findings recorded by the inquiry report. He says that there is already a police report now, meaning there were, I think, charge sheet perhaps, and that is to be made part of a charge, and the findings reached by the inquiry officer is not satisfactory to me. Right. Now, if he holds like that, whether this, you suggested that note of disagreement is to be prepared, right? To be prepared. Whether that is to be sent to the delinquent, which part of it says?
Lordship,
Please read.
denial of the report of the inquiry officer is a denial of reasonable opportunity and a breach of the principle of natural justice. Follows that the statutory rules, if any, which deny the report to employer against the principle of natural justice, therefore valid. Delinquent officer employee will therefore be entitled to a copy of the report if the statutory rules do not permit the furnishing of the report, the line of the subsidy.
There is a principle.
Lordship.
But if before that,
Yes.
because first stage he agrees, and he sends the report. Second one he drops, not required. Third one, where he disagrees, what is to be done?
Lordship. Lordship, Rule 9.
Because it is your objection.
My lord.
That is the ground for filing the writ petition.
And one more.
Please, suspension, that is a different matter.
Now,
Second suspension is a different matter.
now what they have done, they extend the order of suspension. Other than my learned friend made a submission that the reinstatement is under process. It was not there at the last opinion. Then I have come across a communication wherein the order of suspension, no reason, they have to pass what is the order for extension of the order of suspension, nothing.
No,
to
no,
that.
this point.
Yes, communication of the orders.
No.
cross-
Notes of disagreement, which you have made submission on which?
Yes, my. Orders made by the disciplinary authority shall be communicated to the government servant who shall also be supplied a copy of the report of the inquiry held by the disciplinary authority and a copy of the finding on its charge. But I am thankful to my learned, and where the disciplinary authority is not the inquiring authority, a copy of the report of the inquiring authority and the statement of the findings of the disciplinary authority together with reasons for its disagreements, if any, with the findings of the inquiry authority, and also a copy of the advice, if any, given by the commission. Where the disciplinary authority has not accepted the advice of commission, a brief statement of the reasons of such non-acceptance. 9A. 9A.
Rule
9A of the Assam Service.
9A, notes of disagreement is to be forwarded.
Communication.
Okay. Rule 9A. Yes. That is on this ground, you have filed a second writ.
Second, study on furnishing the order of entry. Code of
That is why they have decided to go for fresh inquiry report. Notes of disagreement, that is mandatorily required to be furnished, and which they have not furnished. Okay, what the.
Well, responding to that,
And a second repetition?
Yes. Second, my lords, when the matter was moved, my lord, I made a submission that will be taking instruction, and the second date, my lord,
the court, I also undertook that I'll be giving them a copy of the inquiry report, which closes the matter. In fact, the court was inclined to close the matter, but since both matters were tagged, similar issue, same person, it was tagged. Otherwise, since officers have perhaps he has been communicated with, I don't know about that. I mean, I stand corrected also. But now, what has happened in this case, Lordship may kindly come to page 57. Just second read petition, my lords. The second read the order starts at page 56, for which they have filed a contempt. But first, initially, I have to submit, ballot that we are just assisting as a counsel, standing counsels, my lords. After that, my lords, there was a proposal mooted, and the office of the LR was moved for suggestions. Now, this was the correspondence which was received by me, my lords, whereby, my lord, the secretary of this forest department had sought back the file for process. On the basis of this document, my lord, that statement or that submission was forwarded by my learned friend that we are mooting a proposal. And the learned LR and his office has returned the file, my lords, endorsing a view that we should go for vacation or modification of this order, which is also a part of the order dated.
Which one? I could not understand this.
56, page 56, my lords, of the petition.
These are what?
These are our communications with the LR office, that we mooted a proposal, we sent it for the judicial department for their view, that can this this order can be this order can be complied and be consequently the person can be reinstated or not. Since the office of the LR was not returning the file, my lord, the other communication on the second page, my lord, we asked them directly again that you return the file. That because we are facing contempt.
These are very belated actions. This is.
No, my lord, the file was endorsed to the office of the LR long ago.
This was in April.
It was endorsed to the office of the LR long ago, my lords. So since he was not returning, the office of the LR was not returning the file, that was the communication. Now he has returned the file with the endorsement that, with the advice to the government, Lordship will kindly come to page 58 of the writ petition, my lord. Wherein, my lord, liberty was given to us to move this code. For modification, my lord.
That was meant
No, my lord,
for,
is
not
now
meant for 4 months.
No, now, my lords, since the file has been returned, we are processing this modification application. It might be filed this week or next week. There was a proposal mooted.
September.
September, my lords. And the inquiry report is not with the inquiry report is not with me. Inquiry report which I can produce, my lords. I have a soft copy, a big, my lord, big volume. My lord, the charges are partially proved. The person has not been exonerated.
The question is not that.
The question is like he has to be given. He has to be given.
Because law is laid down in ECI.
Yes.
And that is a constitutional judgment.
I know, my lord.
That is holding the field.
But ECIL also has another part, my lords.
Oh.
ECIL part which I can read, I may be wrong. I stand.
Which part?
There's a part, my lords. Yes, my lords. It was held that there, in an event there's a non-supply of the inquiry report, the courts and tribunals can cause the inquiry report to be furnished the employee and he be given the opportunity to make his case. If after the hearing the parties, the court comes to a conclusion, the non-supply has made no difference to the findings and punishment meted to the charge of employee, my lords.
Question of prejudice.
My lords. Yes.
But so far as this agreement is concerned, there is no further observation.
My lords. Then I can bring the inquiry report on record. And then, my lord, he has been, the secretary has been now directed to advise to supply a copy
One.
expeditiously, my lords. And even the inquiry report says the charges are partially proved.
This is one. If he is retiring, then you file your affidavit within 1 week.
Yes, my
Take
lords.
up, take
My
up for
lords.
final consideration.
My lords.
All three.
My
Let them file affidavit within 1 week. Already notices were issued.
Complete
Hearing is complete.
No.
No affidavit.
service is complete. I have.
Let
Of
the,
the application, my lord.
which
But it was
department?
passed in the year.
Forest department. Forest department. Let them file their
My
affidavit. Put the
Will-
petition
will
within
file.
1 week. We'll take up this matter before retirement.
We'll file an.
We'll file, we'll file.
No,
my lords.
no opportunity. No further opportunity.
My lords.
Monday, my lord.
Yes, because these are moved long back. If you are really a person who is retiring, they should have shown electricity.
No, my lord, since
June,
my lords,
April, we have
my
seen
lords, the
March,
my
April,
lords,
May,
since-
June,
no,
July.
my lord, that aspect, before it started, when this contempt started running, and we have been asked repeatedly before we could address these two writ petitions, my lord, contempt was
You file
keeping
one
under our
affidavit
toes, my lords.
both the writ
My
petitions.
lord.
By Friday.
By Friday? By Monday?
By Monday, my
They
lords.
can work.
My lords.
Weekend they can work, otherwise it is very difficult for
My
them
lords.
also to work. I had Miss Michael and Senior Counsel, Mr. D. Bhumi, Senior Counsel, and Mr. D. Gogoi, and Standing Counsel, Forest Department, for all the official respondents.
My lords. No, the contempt to.
Also heard Mr. H. Alial and Standing Counsel, Finance Department.
Oh, it was time.
Also, having regard to the petitioner is an employee who is going to return superannuation on 30/9/2025. The respondent authorities were put to notice in March and April.
Orders.
I think Thursday.
April.
It's April, my lord.
Were
April.
put to notice. On a 3/2/7, June,
And for 2000.
on 10/4/2025 and 18/6/2005 respectively. Since the issue, petition, the respondent authorities shall file their counter affidavit invariably on or
Monday.
before Monday. Is the case.
Orders.
Interim order.
Put the
They were
case.
passed. Interim orders passed earlier. Welcome.
Put the case.
Interim orders, I say.
My.
Well, please, your lord.
Yes, your case, right?
Yes, my lord,
Some
more
suspension.
more than two.
Some suspension.
But
Some suspension matter.
They filed their affidavit.
If not possible, the first half will take up your case specially at 3 o'clock to 3 o'clock.
Tomorrow.
Right?
Tomorrow.
Because I have to write.
Yes, Lordship.
Okay, J. Patori, petitioner. As Dr. Revenue.
Yes.
Mr. C.K. Porua, for response number 2. That affidavit is on record.
Yes, sir. On record.
Is the case tomorrow? Correct. If possible earlier, the case will be taken up at 3 or 3:30. We'll take up as last item, 3:30. Then we can continue to maybe at 3 o'clock corridor. Okay. Yes, Mr. Islam.
As per office note dated 28/8, my lord. No unserved notice.
Okay.
No
J.
ID
Islam
card has been written.
for the petitioner. Contempt case, Mr. S. Dotto, you are for?
And for respondent number 1, has been transferred in the last year itself, my.
For the sole respondent.
Yes, but now thereafter, respondent number 2 has been implemented, my lord. Which
Okay,
notice has not been served.
New.
Yes, notice has not been served.
Okay.
So
For
it is
respondent number 1, present. Firuzda, please note.
dated
Dated
28/8.
3/8/2025. As regards service of notice upon the respondent number 2. Await for the service report in respect of respondent number 2. This is the case of it.
Unable.
Please, my lord. Service. Oh, my lord.
Heard.
Justice.
Mr. Affidavit regarding justice
Yes,
service.
justice, my lord.
Mr.
A. Dotto.
A. Dotto. Attorney counsel for the petition is. Service upon which respondent?
Yeah, my lord.
Why to the peon, sir? You should have directly sought him. Huh? That is not very difficult for us. If he is the person is present, you are taking a high court notice. Why you serve to the peon?
That my I received on my.
Sometimes disastrous consequence. Right? Not very satisfied. Big face test.
Last. So it is one also beyond my lord.
Officially is different thing, but when we give you, because this person is the executive engineer, but it is by his name. Had it been a writ petition, it is okay. Whether AD is yes. Wait for the service. Good. Yes, it- You serve it, that is why the AD card came back. but it was an illegible
Yes.
signature. Then you should have served him by directly. Take your steps, please, trustee. Served him personally. Just to, it was, no? The affidavit filed in compliance of service of notice served trustee. And the contents of the affidavit are produced. So it is found that the notice has been served not personally to the respondent, but to a peon of the office. Post in view of such fact situation, comma, the petitioner is permitted to take fresh steps for service of notice by way of the respondent. Post of if it complains in 3 weeks, statutory is litigate. Is the case after. Yes.
But here, the direct honorable court is to place it before the SLC. If not totally considered, is placed and is considered.
This is for what? Contempt.
Contempt.
Notice, you have appeared for all.
Uh,
Just come for only service.
Only
one respondent, I'm appearing.
You have appeared.
I'm appearing and the direction kindly come to page 22.
22.
Page 20. Second.
Considered.
SLC has come. The order has been, I think.
Then whatever is there, we can close it. Only is that to place. We heard Sir L. Mohan, Land Council for the not Land Council for the should respond. Post of this contempt petition is preferred. Alleging non-compliance of the direction made in an order dated 21/2024. Passed in a writ petition. WBC number 871/2020. The operative part of the order dated 21/2024 reads as under case 20. Mr. D. Nath, and the counsel for the respondent has submitted that the case of the petition was placed before the state level committee for appointment on conviction ground on 24/2024 and 24/12/2024, and the SLC had considered the case of the petitioner and thereafter rejected the same post of in view of the taking note of the directions made in the order dated so and so, and the fact that the SLC has also already considered and disposed of the application of the case of the petition for completion and appointment before 12/2024, the no further issue survives in this contempt petition. Full stop.
Indicate decision has been taken as the direction of the honorable court to indicate that this level committee was not.
Will finally speaking. They are lost and they speak order. The speaking order has been. The departmental secretary has passed the speaking order on 2/1/2025. I have given a copy, Miller.
and it is marked to him.
And after consideration of the case of the petitioner by the SLC, comma, a speaking order dated 2/1/2025 has also been passed by the Secretary to the Government of Assam, comma, Public Consumer Affairs Department. Mr. Mohan, learned counsel for the petitioner, has submitted that the order first decision of the SLC and the speaking order passed by the Secretary to the Government of Assam have not been communicated to the petitioner. Full stop. And the same sorry, and the direction to communicate the order, the part of the order dated so and so. Be that as it may, comma, the Mr. Nath and counsel for the respondent shall hand over a copy of the decision taken by the SLC on 24/12/2024 and the speaking order dated 2/1/2025, Supra, Mr. Mohan, today, during the course of the day. Full stop. Having regard to the above, comma, above such situation, comma, this court is of the view that nothing further survives for adjudication of the writ petition. The writ petition is closed. The petitioner is at liberty to avail appropriate remedy under the law. If he is aggrieved by the decision of the SLC and the speaking order, so pass. The contempt petition stands closed. Right.